My lord, may I pray for listing of a writ appeal on 19th April?
What is it?
Fresh matter.
When was the order passed?
Order was passed last week, but I have been made to vacate the tea stalls. I'm running at Kamakya and Guwahati railway station. So lordship, there is urgency in it.
It listed on 19th, yes.
Much.
Made to your lordship. I also pray for a similar relief, your lordship. Listing of a writ appeal. It was last listed on 25/1/2023, and it was directed that the matter may be listed after 2 weeks. Thereafter, not listed, your lordship.
All right, 19th.
Oblige, lordship.
But on these matters which are already listed once, you have to be sure that there is no date provided by the office. If there is a date provided, then you have to file an application for early listing, because the other party would be taken by surprise. So you find out first, in his case, find out what is the date fixed.
Yes. Occasion, no date was fixed. It was just mentioned that list a matter after 2 weeks.
The registry might have given a date now.
I'll check.
Yes. Have you checked on the internet? The dates might be posted on the internet.
Internet, no date as such given.
No date. All right. We'll find out. Yes. Okay.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 13 of the daily.
All
We
right.
have
13.
submitted adjournment request.
Saiwala sir, what do you say
Well, sleep has been given.
on request of this 2019 matter? Why do you want to get it adjourned now?
Lordship, on last occasion, as directed by this honorable court, the bank officials of the respondent bank has appeared, approached before the Shivsagar police station, seeking police aid so as to hand over the vacant possession of the petitioner in question. Your lordship.
Right.
But the officials, but the police authority has did not.
Then why do you want to get an adjournment? Let us pass some order.
No, your lordship, because my senior has instructed me to that he wants to file some application, bringing it on record about the.
All right. And council, a request is made to adjourn the matter on behalf of the respondents. By respondents council submitting that he is desirous of filing an application to bring on record certain important facts. List on 9th May, 8th May rather. Okay.
Much obliged.
May it please your lordship. Lordship, may I pray for item number 19, lordship? This matter will be taken up immediately after vacation, lordship.
As prayed by council for the appellant, list after 3 weeks.
Lordship,
Yes.
in respect of item number 10, today I have filed our affidavit in opposition.
Number 10.
Item number 10, lordship. Kindly call for the same, lordship.
So you wanted the matter to be taken up today or what?
Today, lordship. That-
All right, affidavit Mangaliji, call for the affidavit.
Item number 1 of daily list for orders.
May it please your lordship.
Yes.
Lordship, SLP is still pending before the apex court, lordship.
SLP referred to in the earlier orders has still not been decided.
Lordship, lordship,
List after 6 weeks.
lordship, lordship. Oblige, your lordship.
Item number 2.
Well, here, Malad, notice was issued, Malad, and my learned senior friend, he has entered appearance, Malad.
All right.
I would like to file an application. They have given an application where some annexes are not there. We'll coordinate with them and we'll file our objection.
Council, Mr. Bhaskar puts in appearance on behalf of the, which respondent? Sole respondent?
1 to 9, my lord.
Respondents numbers 1 to 9. Thus, service is complete. He prays for, and senior council prays for, and is granted. How much time do you require? How much time do you require?
Your lordship will give you that any date in the first week of May.
Praise for is granted 3 weeks time to file what?
An objection to their condemnation of delay petition. Which
An objection to the application seeking condemnation of delay. List on
557.
10th May.
Deeply obliged.
Oblige, lordship.
Item numbers 3, 4, and 5.
My lord, the contempt application is before your lordship. Now, so far as the respondents, my lord, are concerned,
Yes.
my lord, the they have been duly served. My lord, I have filed an application, affidavit, my lord, bringing on record the service of Dusty. My lord, in fact, in the month of February itself, my lord, both the respondents, my lord, respondents 1 and 2. In fact,
Do these officers continue to hold the post?
in fact, my lord, the honorable single judge, my lord, has observed that I have deemed to continue, my lord.
The respondent officers, are they still holding to the, holding on the post?
Yes, yes.
All right, you are appearing.
My lord, I'm appearing for the department, my lord. Till that they have,
There is no department in the contempt, sir.
my lord.
Do you represent the officers or not?
In the contempt, my lord, I'm not representing yet, my lord.
All right, then we'll require personal attendance of the officers.
My
Then
lord, I have telephonic instruction, my lord. They are sending the wakalatnama, my lord.
then don't make such statements, Mr.
My lord,
Counsel. You know the consequence.
My lord.
If the contemptor is served and is not represented, then we'll call the
My
contemptor.
lord.
2 months back, my lord. It has
What is this statement?
My lord, short date may be fixed. I'll file a wakalatama, my lord, on behalf of the.
You undertake to file
My
wakalatnama?
lord.
Then counsel Mr. So and so submits that he has been instructed. Mr. M. Bhattacharjee,
As doctor.
as the two submits that he has been instructed to appear on behalf of all respondents. No. You will be for 1 and 2 only.
Yes. Do-
So what about 3? No one is there? Response numbers 1 and 2.
1 and 3, my lord.
Are you sure?
Yes, my lord.
1 and 3. What about 2? No one appears for respondent number 2, despite service. 2 and 4. 4,
I'm filing my wakalatama today.
4. Mr. Nayak appears for respondent number 4. Respondent number 2 has not appeared despite service. Thus, he be notified to remain personally present in the court on the next date of listing. Reply oblique compliance report on behalf of the other respondents be filed.
Lord, may I submit? In this case, Lordship, I have filed one appeal, Lordship, and this honorable court was pleased to stay the order.
There is a stay.
No
Yes.
stay, my lord.
Status.
Only honorable court has directed its status quo.
Status.
Status quo means, my lord, I'm continuing.
No, at that point of time, I was continuing.
All right, then, reply on behalf of the duly represented respondents be filed. Reply affidavit be filed by next date. The respondent number 2 shall personally be notified to remain personally present in the court on the next date. List on 10th May. It's okay. 10th May is okay?
Can it be shorter, my lord?
Hmm?
Can it be shorter?
Shorter than 10th May. All right, let's have it on 3rd May then.
Oblige, my lord.
Very
Deeply
Then,
oblige.
my lord.
Let it be 10th May, okay.
Oblige, my lord.
Item number 6,
Yes.
Well, the department has already signed the copy, but given the copy to me. I'm just filing it to be.
Okay.
Within
Mr.
half an hour, we are filing.
Nath submits that he would be filing the counter affidavit during the course of the day.
Lordship.
All right.
For respondent number 2.
You given for the respondent number 2
2.
on behalf of the respondent number 2.
Two.
What about the other respondents?
Lordship, I'm appearing for respondent number 3.
1
One.
last date you put in appearance for 1 also.
Yes, yes, well, I'm for one certificate is not ready.
Not required.
Not ready. I need some time. For 2, I'm filing to develop.
What is the contempt petition? Let us see. What is the order under contempt?
Lordship, may kindly come to page 14 of the page.
Yes.
14, Malad. The direction is at page 16, Malad.
Initiate the process of selection for promotion to the post of director.
Yes, my
So
lord.
what has been done?
Subsequently, as there is no time limit was given, they filed a petition.
So you can take ages to
My lord,
initiate the
my lord.
process.
Malad has clarified that on 17/8/22, page
Yes,
8, page
yes.
18.
Hmm.
Malad, in the affidavit, Malad, my instruction is that Malad, they have initiated the process, Malad, after.
No, but since there is no cutoff date, they can carry it on
No.
for years together.
No, the thing is that my instruction says that in the meantime, at the highest level of the government, there is they have a policy decision has been taken. to bifurcate the department into Directorate of Geology and Director of Mining.
You may do it at your own convenience, but this promotion process has to be completed.
But, and also they have taken a.
Then all right, keep your officers present in the court on the next day.
Yes, my lord.
Lordship, may kindly.
Mr. Counsel, this
let
is
the-
not to be tolerated. We tell you very clear.
Let the affidavit come on.
This is simply playing around with the court's orders.
No, Malad,
Nothing beyond that.
kindly allow us.
You keep
to-
your officers present then.
Malad,
All right.
Kindly allow us to have the affidavit on. record.
What about the 2 months direction? What has been done?
Malad, let the affidavit come on record. Malad, kindly take up tomorrow. if-
Pass over. Bring the affidavit right.
Lordship.
All right. Yes.
Item number 7.
Yes.
Lordship, 2 weeks may be granted for filing affidavit in opposition.
All right. And counsel MS so and so appears for the respondents. All respondents
Respondent,
Sole respondent.
is
sole res-
sole respondent. She prays for and is granted 2 weeks time so as to file an affidavit in opposition to the interlocutory application seeking condonation of delay.
Lordship.
yes.
List of 2 weeks.
Item number 25 of supplementary list for order.
Yes.
Lords, this is a writ appeal against an impugned order of the 3rd of March.
Yes.
This is an eviction matter, my lords. This is an appeal. There's a delay of 7 days.
What do you say? Condonation?
7 days and.
This writ appeal is delayed. The connected writ appeal is delayed by 7 days. Interlocutory application number so and so has been filed by the appellant seeking condonation of delay occasion in filing the writ appeal. The prayer for condonation is not opposed by the respondents. Otherwise also, the reasons are sufficient. Hence, the delay is condoned, application is allowed. The registry shall number the connected writ appeal and shall list it on. When do you want
My lords, sometime after the short.
list it on 28th?
My lords, just one submission. The stay granted in the impugned order ended yesterday. So we would seek extension of that grant of stay.
As on date, your appeal is not numbered. In which proceeding will we pass the stay order? You instruct your officers. All right, it's a difficult situation which has been created. Instruct your officers not to dispossess. There's an order of disposition,
My lords,
demolition or disposition.
The writ petition was dismissed. The eviction
Oh.
order was upheld.
Eviction, it's an order of eviction. All right. So
Eviction has already been completed, your lordship.
No.
that is a disputed question now.
Lordship, may kindly come to page number,
Yes. Page number,
page 72, the order starts, your lordship.
para number.
Lordship, page 85, your lordship,
Para
para 44.
44.
Lordship, in this writ appeal, they have mainly raised the contention against the virus of the Rule 18 of this, of the Assam Land and Revenue Regulation, your lordship. In paragraph 44, your lordship, the Honorable Single Judge has contended, your lordship. May I read, your lordship?
My lords, just that my learned friend is actually raising that point. Can I actually say 3 issues on which the writ appeal is actually based?
Right now, she wants to highlight that the eviction has already been completed. Where do we read that?
The eviction has not been completed, my lords.
There's nothing in the para 44,
There
madam.
is the stay which has been granted by the Honorable Single Judge. I'll take you to paragraph, the last page, my lords, 87.
Till 10th April, they are protected, madam.
Yes, my lord.
The order itself says yet they are protected. How do you say that they have been?
They were given the time to vacate the land, your lordship.
So they have not till 10th April, that time was there.
My lords.
Most of the people who were residing in that area, they are already evicted, your lordship.
They have been, yes,
May I interfere?
yes.
Those 10, up to April 10th, it was given only to those families who have, there is a word who is appearing in examination. The rest, there was no stay.
No, my lords, there is no such distinction
No,
that
there
has
is
been made
distinction.
in the impugned.
Those
There is a-
cases, yes.
There is a- in a
Yes, yes, there is a
paragraph
distinction.
48.
Yes,
At this stage, this court has
Yes.
been given some thought to the individual hardship of serious
yes,
nature.
yes,
Those
yes.
specific pleadings are not there in the petition. It has been.
My lords, the sole appellant is
I am
actually.
reading.
Well, all right, but your appeal is not numbered. It will come up on 20th. Argue, then satisfy the court.
My lords,
That the
appellant
eviction is
actually
illegal.
a Cancer patient and her
Definitely,
house
that
has-
can be also considered, Lord. If he has individual hardship regarding a patient having cancer, definitely we are not
The
going to.
appellant in this particular writ appeal is actually a cancer patient. my lords. I can actually.
Whether-
The individual
these-
case, no
These
decision.
documents are all part of record. Your case that your appellant is a cancer patient, is it a part of record?
My lords, I can actually present those documents.
Counsel, then you are taking the government by surprise. If it is a part of record, they can very well direct the officers.
All that I'm saying is that till the 10th of April, there was a stay that.
All right, so you got delayed in filing the appeal.
I.
Then what to do?
In fact, they were.
That time was granted looking to the fact that the children were to undergo examinations.
My lords,
They were to take examinations. That period is over.
my lords, I agree. But in this particular facts and circumstances.
So you are coming out on a peculiar facts of a particular litigant, but those facts are not in your writ appeal.
My lords, I agree. But the point is that the.
AG sir, you have a look at his documents. You find something.
They were directed to submit all the documents. Third line in page
Yes,
is
Which
87.
we have, my lords, which we have submitted before the district collector.
Where is the copy of your representation?
We will submit that too, my lords.
Oh, we will submit. Then what is the appeal about, sir?
The appeal. is-
Everything will be thrown across the board. Where is your representation saying that the appellant is a cancer patient? What kind of irresponsible pleading is this? Read out from your representation. Yes. It's too casual. Absolutely.
My lords, in the representation, we have pointed out that on the wires of the order, not on the cancer patient. my lords.
Number the appeal and list it on 20th. Sorry, sir. This is absolutely unacceptable.
Highly obliged.
AG sir, your attendance is to be marked.
Yes.
All
I
right.
was appearing before. the
Mark
last.
the attendance of London Advocate General.
Item number 26 and 27 for orders on interim application.
Yes. Yes.
The impugned order is on page 67, my lord. There.
There is a stay already.
Yes, my lord.
Today it's for service or what?
Yes, my lord.
Notice. Who is appearing?
For a respondent.
Hmm?
Respondent number 3. the deputy-
3.
Others are any considered with regard to the panchayat development.
Neither AD card nor unserved notice in respect of respondent number 5. What is that? Let's see first this one. Panchayati Raj Department, Panchayat Department, you are appearing.
No, my lord, item 27, my lord.
Right
Respondent
now,
number 3, my lord.
we are having file of item number 26. 26 on the last date, Mr. K. Komar, MSS Komar, JMA Chaudhary. All missing in action. All right. None appears on behalf of the respondents. As per the office report, service has not been effected on respondent number 5. Fresh steps be taken within 3 days. Whereupon, process be issued to such respondent. Interim order shall continue till next date. Rule is made returnable in 6 weeks. 27. 27 is a different matter.
No, my lord, same matter, same cause of action.
Same cause of action.
My lord, similar matter, my question is that, my lord, here the private respondent has filed an interrogatory application for vacating the interim order.
Who is representing the private respondent?
But the advocates are not.
Where is the application? It's not listed on the application, no? It is
It is mine.
27. From Saikia.
Mine.
All right. Matter comes up for orders, IA number so and so. Orders on IA number so and so, seeking vacation of ad interim stay. They pass in favor of the writ appellant.
Mine.
Nobody is present to.
Respondent number 3, mine.
Nobody is present to argue the application. List after 6 weeks along with so and so. Interim order shall continue
Object.
till next date.
Item number 8 of daily list for fresh admission which stay.
Yes.
You know, this matter was listed, the last day, the London Advocate General had also.
Yes.
I have received the instruction from the school authority, Lordship.
Yes.
They have withdrawn that order and they have also said.
Maybe you persuaded them to do so.
Yes, Lordship, there is no point of having a commercial complex in the school area.
All right.
I'm giving one to them.
All right. Then Advocate General Shri Saike has placed on record copy of the communication dated 8/4/2023 issued by the principal Nahar Katia Higher Secondary School to the Inspector of Schools, Dibrugarh Circle, conveying that the proposal taken in the SMDC meeting dated 15/11/22 for constructing commercial establishments has been changed and withdrawn. The SMDC now plans to construct the school buildings in an orderly manner so that the students can be facilitated with a better classroom environment. The school, the letter also indicates that the school has already been listed for grant under the PM Shri School. In this way of the matter, we close this PIL because cause of action does not survive. The efforts of London Advocate General in ensuring that the commercial construction does not take place in the school are appreciated.
Deeply obliged.
Deeply obliged. Item number 9.
In this case, Your Lordship, the appellants have filed an additional affidavit along with the writ appeal, Your Lordship,
Yes.
bringing in some new facts, Your Lordship. We are preparing a counter to that, Your Lordship. We need some time to, Your Lordship, file.
Then counsel for the respondents, pray for and are granted. Praise for and is granted. Additional affidavit was filed when?
It was filed, Your Lordship, on last occasion, it has been furnished to us, Your Lordship.
Has it been brought on record?
It should be in the.
Last date, the order was simply to rectify the errors
Lordship.
in placing the next years. You
And
filed
on
it thereafter.
On that day, Your Lordship, the copy has been furnished to us.
The affidavit, only affidavit which is there is of 1st October.
This is, Your Lordship, IAS, the additional affidavit, Your Lordship, on behalf of the appellant.
Yes, that's.
That's 1st October.
Yes, that is.
Copy
the
has been furnished to us.
All right. Then counsel, Mr. So and so. What's your good name, sir?
As board approval.
As Botakur, appearing for the respondent number 1 or sole respondent
Sole response.
for the respondent, sole respondent, submits that he has received copy of the additional affidavit dated 1/10/2022 a few days back and would require some time to file a counter thereto. List after how many days?
2 weeks, Your Lordship.
2 weeks as per.
Deeply obliged.
Item number.
Yes.
It is a Lordship.
Hmm? Yes.
On the last occasion, my learned senior made a submission that there is a policy decision to get done away with TET. There's an affidavit which my learned senior has filed, Your Lordship.
Yes.
Paragraph 8 of my affidavit, Lordship.
Page 230.
So what do you say after this affidavit?
our main grievance regarding a lot of vacancies which still arise, they still stay, but my learned senior has made an effort to get away.
So if this requirement is done away with,
Yes.
the next recruitment would take care of your issues.
Yes, Your Lordship, that should suffice.
So we can close the matter then,
We can
in light of this
Yes, Your Lordship.
affidavit, and we'll reproduce this
Yes.
para 8 in the order.
Yes, Lord.
All right. So it's disposed of in light of the amendments made in the affidavit. Mr. Saikia, Mr. Chaudhary, a general question to the members of the bar. Is this system of listing somewhat more, having more clarity or not? The cause list, have you seen the change?
Yes, Lordship. Different categories. Oh, sorry.
The categories,
No, and I have not noticed.
senior advocates are not required to see the list. No? They only come in brief matters. All right. You have changed the system of list. You just have a look at it.
Yes.
Because practically, I was finding it difficult to fathom out what is the category in which the case is coming. So now these categories, which they are operating there in Rajasthan, we have introduced them in court number 1 for the time.
The different heads, my lord.
We just have a look at it. It will not take very long for.
Okay.
This has been notified also.
It's good, my lord. Yes. In
So-
fact, my junior prepared a list for me more or less akin to that.
Okay.
They
Yes.
have a heading called.
So we can, this is the notification, you can have a look at it.
Yes.
So if it's all right with the members of the bar, we can introduce it in all courts.
Yes,
Actually more convenient. Lordship.
You know under what head the case is listed.
yes.
Their
think
motion, we call it a fresh
consequently-
admission,
All-
fresh.
All heads are more. or
Yeah,
less-
yeah, more or less. There we call motion as a fresh admission.
Okay.
Yeah, which has not been taken up even once. So we'll close it by recording your statement and para number 8. Dispose of.
Item number 11,
Deeply obliged.
Sorry, sir.
Yes.
And on last occasion, my lord, lordships wanted to see some authority on the point. It's a
You
matter,
will-
my lord, where we are questioning the competence of the state to frame the regulation whereby, my lord.
309, 323E.
Yes, yes.
Yes.
My lord, I have given the list, my lord. First judgment which I would like to place is, my lord, 1995 Supply 1 SCC 572.
Just hold on.
Yes. My lord, may kindly come to paragraph number, my lord, 19.
Yes, please. Mr. Chaudhary, can you give a brief outline of the matter? Because my
Yes,
brother was not there on the bench
yes.
when you argued the matter last date.
For the benefit of Honorable Justice Saikia, let me
Yes,
point out, my lord.
please,
What had
please.
happened in this case, the state government, lordship knows under Article 320, sub-article 3 proviso, sorry, not the proviso, sub-article 3 of Article 320 mandates that in case of certain recruitment, the Public Service Commission must be consulted. However, the proviso carves out an exception to the extent that if the state government or the governor frames a regulation under that power, that is the proviso to Article 323, that in certain situation, in certain administrative exigencies, the post can be taken out from the purview of Public Service Commission, and the recruitment can be made by any other manner. Now, that is the legal position. Now, what the state government did, state government had framed a regulation under proviso to Article 309, whereby a recruitment board has been constituted. Simultaneously, what the state government did, State government also amended the recruitment rule, where earlier the recruitment was to be made by the commission. Now the power has been given to the board. So I'm challenging the framing of the regulation as well as the amendment. That is the background.
Right.
Now, if a lordship should kindly come to para 19, my lord.
Yes.
It is true that in Divakar and in Venkat Reddy case, this court upheld the exercise of power by the government under proviso to clause 3 of Article 320 of the Constitution, and in Venkata Reddy held that temporary employees are appointed in accordance with rules. As stated earlier, those appointments came to be made during ban period and remain in service for a long. In this case, there is no ban on recruitment, and appellants were eligible to apply for and seek direct recruitment. In Paripurnam's case, another bench of 3 judges, considering the similar Madras rule held in para 14, that temporary employees made under Rule 10A1L to fill the emergency vacancies were otherwise then in accordance with the rule, and temporary service cannot be counted towards seniority. Same is the view held by the another 3 judges bench in APM Mankutti versus so-and-so. In Divakar and Venkat Reddy's case, this court approved the validity of the exercise of power under proviso to clause 3 of Article 320, owing to ban on recruitment by the government and long lapse of time, which had elapsed from the date of initial temporary appointment till the date of the decision was taken by the government to regularize the services of such temporary appointment. In Vatnagar, this court, while deprecating the practice of the government by giving a go-by to the statutory rules or regulations framed under proviso to Article 309 of the Constitution, making large-scale departure, expressed the view as thus. On more than one occasion, this court has indicated to Union of India and the state government that once they frame rule, their action in respect of the matters covered by the rules should be regulated by the rules. The rules framed in exercise of the power conferred under proviso to Article 309 of the Constitution are solemn rules having binding effect. Acting in a manner contrary to the rule does not create problem, does create problem and dislocation. Very often government themselves get trapped on account of their own mistake or actions in excess of what is provided in the rules. We take serious view of these lapses and hope and trust that government both at the center and in the states would take note of this position and refrain from acting in any manner not contemplated by their own rules. It was reiterated in Keshav Chandra Joshi, and it is in common experience that it is a vicious circle that initially government imposed ban on recruitment and make massive ad hoc appointment during the rule, giving a go-by to the make recruitment in accordance with the rules, and then resort to regularization of such appointment exercising power under Article 323 proviso or Article 162 to make them members of the service. This practice not only violates the mandate of Article 14 and 16, but also denies to all eligible candidates their legitimate right to apply for and stand for selection and get selected. In so-and-so versus so-and-so, it was held that appointment made in violation of recruitment rule violates Article 14 and 16. Now, this is important. Therefore, as stated earlier, the administrative tribunal has rightly expressed unhappiness on the exercise of the power by the state government by resorting to proviso to clause 3 of Article 320 to make massive departure to make recruitment in accordance with the rule.
This doesn't indicate.
No, I'm coming, my lord, this line. We agree with Mr. Guru Raja Rao, the Learned Counsel for the Public Service Commission candidates, that PSC must be made more functional and its efficacy be streamlined, appointing people of eminence, exercise, experience and competence with undoubted integrity to recruit the candidates in accordance with the rules for appointment to the post, and backdoor entry by nepotism be put to an end. Free play of exercise of power under proviso to our clause 3 of the Article 320 would undermine the efficacy of the constitutional institution. Lordship is correct, my lord. Lordship, these were in the context of initial ad hoc, then regularized by resorting to, it was in that context it was said. But nevertheless, my lord, now the other day my learned friend Advocate General placed one judgment, that is 2008 3 SCC. Even in that judgment, the Honorable Supreme Court has said, my lord, the departure can be made only in administrative exigency in certain situations. Now, my lord, my humble submission is, now there is a constitutional mandate. the mandate is this recruitment has to be done by Public Service Commission. It is a fact, my lord. There was a time in the Assam Public Service Commission, there were a lot of problem. And my lord, that man is behind.
That is so in every public
Yes.
service commission.
Here it was more pronounced, my lord.
We can tell you,
Yes.
when they stay in Rajasthan, the selections to the judicial services were assigned to the Public Service Commission.
Achha.
One of honorable judges was also part of the interview board. And the members of the Public Service Commission were having slips with them in advance. That that is information coming from the horse's mouth. So.
Yes. Anyway, my lord, I'll not.
So there is no the situation.
Yes.
Situation, we don't need to intend to make any comments.
Yes.
But the situations in the commissions are not ideal.
Yes, not ideal.
That's-
Anyway, my lord, now what had happened since 2016, my lord, new regime has come. Now they have, made overhauling of the whole thing. Now at least things are, my lord, visibly, my lord, not so bad. It's going on.
Right.
So therefore, my lord, the state also cannot take the plea that the earlier regime is there, therefore we can.
Maybe not that plea, but that the other plea regarding the commission not being able to keep pace.
No, if that is the case, that's a different. But if that is the case, then my lord, Supreme Court has said, yes, that is permissible. That will be one-off case. It can't be you altogether, my lord, take away the function of the public service.
Not altogether. This is in relation to a particular set of service.
No, even
Not-
there, my lord. Even that cannot be done, my lord. In my humble submission, my lord.
Can you convince the court that merely by making the rules for recruitment to one set of services, state services, the commission is being made defunct? Can you satisfy the court?
No, my lord, not only here in yes, I'll come to that. Now, it can so happen in respect of a particular recruitment. My lord, in Divakar's case, which I'm going to place now, what had happened? My lord, this Public Service Commission was intimated on several occasions. Then they expressed their inability. It is in that circumstance, 97 posts of tax collectors in the state of Maharashtra was taken out. That was put to challenge. Their Supreme Court upheld it. They said it was in the context it was done. But for posterity, it has been taken away, my lord, by framing the regulation. That can't be done, my lord. Now, I'll just place now, my lord. Here I place the judgment for the proposition where the contention of the council was accepted that the efficacy of the institution cannot be undermined.
Of course.
Yes. Then my lord will kindly come to the Dibakar's case. That is, my lord, 1999.
Mr. Chaudhary, you have to be realize that this was in context that the appointments were made on ad hoc basis.
Yes.
They were not made by framing a new set of rules. That's the difference.
No, my lord, by whatever, the intentions may be very good.
Right.
Question is whether, my lord, judicial imprimatur can be
The
given
question
to
is
such an action.
competence to frame rules.
Yes.
That is what the rules will be declared to be ultra
My
vires
lord,
only.
My lord, my humble submission is if state would have taken recourse to proviso to Article 323, then it would have been different. But by invoking 309, how can they do it?
That's what the
that is
query
my
was.
point.
But this judgment does not answer
No,
that query.
directly does not answer. Yes.
Yes.
Now, my basic argument is, my lord, if the state government take recourse to proviso to Article 323, then it would be different.
Right.
But, my lord, they cannot take recourse to proviso to Article 309.
So you cite a judgment on on that issue, on
Yes,
that aspect.
yes. My lord will kindly take this Dibakar's case.
Yes.
1999 1 SCC 354, para 24 and 26.
Yes.
Para 24 and 26. My lord, this case pertained to, my lord, interpretation of the word may, where consultation with the Public Service Commission was required, my lord. It was in that context.
Right.
Where it was said the word may has to be read as shall and it is mandatory. Kindly Rule 24, general principle of seniority. Subject to other provisions of this rule, the seniority of a government servant in any post, cadre or service shall ordinarily be determined on the length of his continuous service therein. This is the general rule. Second proviso, if your lordship will kindly see, my lord. Provided further that this service, if any, rendered by him as a result of fortuitous appointment shall be excluded in computing the length of service, and for the purpose of seniority, he shall be deemed to have been appointed to a post or in the cadre of service on the date on his regular appointment is made in accordance with the provisions of the recruitment rules. Now, this was, my lord, interpreted. Kindly come to paragraph 26.
Yes.
Coming to interpretation of Rule 4A, it is no doubt true that language used therein indicates that the said rule is made applicable retrospectively from the date when rules were made applicable. Rule 4A opens with a non-obstante clause and provides that if in the opinion of the state government, the exigencies of service so require, government may in consultation with MPSC, wherever necessary, make appointment to the post in relaxation of the percentage prescribed in Rule 4 of the rule by promotion and nomination. The tribunal held that the word may used in this rule is directory, but in our considered view, to give such a meaning would render the very object of consultation with MPSC wherever necessary nugatory. It would give unbridled power to the government to dispense with consultation with the MPSC, which may result in arbitrary exercise of power by the authority. This could never be the object of Rule 4A. In our considered view, the word may must mean shall, and in this case also obvious from the correspondence between state government and MPSC. The government of Maharashtra wanted to relax the quota rule, but MPSC was not agreeable and ultimately relented to the request of the government of Maharashtra and suggested amendment of the rules. So here also, my lord, where the consultation was, the word may was there, my lord, the Supreme Court said no. The expression may has to be read as shall. Well, the whole idea is, my lord, the institution of the Public Service Commission has to be given
Cannot be
a
undermined.
legitimacy.
Yes.
Then, my lord, now my learned friend referred to the judgment, my lord, 2008, 3 SCC 148. Now let us see, my lord, what the Supreme Court had to say here.
Yes.
I'll rely upon paragraph 77, 78, 79, and 86. At page 165, my lord. It is clear that the proviso to clause 3 of Article 320 of the Constitution empowers the governor of a state to withdraw from the purview of Public Service Commission. I'm sorry, madam. Para 77 at page 165.
Yes.
It is clear that proviso to clause 3 of Article 320 of the Constitution empowers governor of a state to withdraw from the purview of the Public Service Commission services and posts in connection with the affairs of the state to make regulation in support thereof. So it is only on the exercise of this power it can be done, not proviso to 309. In the instant case, as has been indicated in detail by the High Court, the state government took steps to withdraw 97 posts from the purview of Public Service Commission after the state commission expressed its inability to fill up the vacancies within a short span of time because of the various reasons indicated by it, such as shortage of staff and malfunctioning of the obsolete machinery and equipment. It is in such circumstances, also on account of the fact that collection of revenue was being seriously hampered, that the state government in its cabinet ultimately took the decision to withdraw 97 posts from the purview of the Public Service Commission to have them filled up on the basis of the limited departmental examination. Then, my lord, will kindly come to para 86, my lord.
Yes.
We agree with the view expressed in Jackie Khan's case that once power of the state government to withdraw certain posts from the purview of the Public Service Commission in certain exigencies is accepted, it would naturally follow that rules of recruitment as applicable to commission would not apply in respect of the said 97 posts, and same could be filled up by the state government in keeping with its prescribed norm. So, my lord, the preponderance of judicial view in my humble submission is, my lord, yes, in an administrative exigency, by invoking power under proviso to Article 323, certainly the state government or the governor is empowered to withdraw certain posts and make recruitment in a manner which is not contemplated, without consultation of the commission. But, my lord, whether by framing a regulation under proviso to 309, that power can be taken away for posterity. That's the issue which falls for your lordship's kind consideration. In my humble submission, my lord, it would be difficult to accept the proposition which state government would like to advance. Because now the effect is, now for all time to come, as far as recruitment of lecturers and others in the technical institutions are concerned, This will be recruited by the board.
Board only.
And altogether, my lord, the institution of Public Service Commission has been done away with. I don't think, my lord, that is feasible. And finally, my lord, one judgment I'll rely upon. Keshavananda Bharati's case, one paragraph, my lord, majority view.
Yes.
My lord will kindly have that. Yes, my lord, 1973, 4 SCC 225, para 475.
Yes.
That's, my lord, the Chief Justice Sikri's judgment, my lord, the majority view. Para 475, small e.
Yes.
My lord will kindly come to page 405.
Yes.
This is the majority view. The opinion was expressed by Chief Justice Sikri, my lord.
405.
405, my lord, page, para 475. After holding Goloknath and all to be unconstitutional. Article 368 does not enable Parliament in its constituent capacity to delegate its function of amending constitution to another legislature to it or to itself in its ordinary legislative capacity. Not to speak of anything, my lord, even the Parliament in its normal legislative power, it cannot, my lord, undo a constitutional provision. What is the scope of a subordinate legislation, my lord? So therefore, my humble submission is, my lord, it is open to the state government to frame a regulation in terms of proviso to Article 323. But they can't do by exercising power under 309, as has been done in the instant case. That is my humble submission, my lord. Therefore, the impugn advertisement and the impugn selection process, in my humble submission, my lord, is without authority of law, my lord. Otherwise, my lord, the other part I have already argued, my lord.
Regarding?
My lord, that why the advertisement is not maintainable. Basically, my lord, if the regulation is not...
Your argument is only that regulations are ultra vires and therefore the advertisement has to go. All right, right. Okay.
That's my humble submission.
Yes.
So basically, they have challenged the amendment part, which Lordship will find at page 86 of the memo of appeal.
Yes.
So here we have amended the existing rules, frame number 309. The existing rules was of 1981.
Right.
So whatever we have done, Lordship, it is in respect of 309. Here,
So the original rules were obviously framed under 309.
309, and we are amending it instead of the commission, we are replacing with board. Whether that we can do or not, whether that has violated any of the provisions of the constitution. Now, Article 323, whether that is a mandatory clause or not mandatory clause.
Okay.
I have a direct judgment to that effect. It is directory in nature.
Let us see.
First, let us place that provision of Article 320, sub-article 3.
Yes.
The proviso part. Article 320, functions of the Public Service Commission. It shall be the duty of the Union and the State Public Service Commissions to conduct examinations for appointment to the services of the Union and the services of the state respectively.
Right.
I am coming to 3. The Union Public Service Commission or the State Public Service Commission
Shall be consulted.
Shall be consulted.
Right.
Now, whether this shall, what is the interpretation of the Honorable Supreme Court later? Shall be constructed on all matters relating to methods of recruitment to...
He has not even argued on that.
Yes.
His case is that is rules, whatever you wanted to frame, taking out from the purview of the commission, the recruitment to these technical services, education services should have been framed by resorting to power under the proviso to
we have not touched Article 320 at any point of time. We have not done it. Now, suppose 309 rules we have framed. In the very beginning, we said there will be a board. Would that have been in conflict with Article 323? Then the things would have been different. But from very beginning, we said that we are going to do from 1981 onwards, that it will be commission. Later on, we found that commission, it is very tedious process. They have lot of backlog.
Is there any discussion
Yes,
to this effect?
yes, Lordship. That I will have to bring on an affidavit.
Naturally, yes.
Because what was the legislative intent for
Yes.
the amendment? It was not a very happy situation to constitute the board and start functioning. When we have a ready commission at place. But when the commission was, there was a lot of backlog in it, and these are teachers. The institutions are suffering.
Naturally.
So that is why the government deemed it fit that instead of putting the burden on the commission, let us have a board so that the things will become more aggressively. It can be done at a lesser with consumption of time. So that was the intent that I can bring on the affidavit. There is no difficulty on that. Now, whether while amending, we have to touch the Article 323.
Right.
Because we are what we are touching. We are touching 309. If 309 is bad or it is in conflict of 320, then the 1981 will also go.
In 1981, you had already
We are following
you had stipulated the commission to be the recruiting authority.
recruiting authority.
So
we
you
have
now
to
by
touch it.
virtue of this amendment,
Yes.
you have excluded the commission, and their argument is
Yes.
that exclusion of commission,
Now, one very important aspect. Who were
Yes.
they?
that is not relevant.
And it is relevant here from my humble submission, Lordship,
Mhm.
because they entered into the service through departmental examination.
Who?
They are appointed under Article Regulation 1951 3F. So when APSC could not do it, the department to tide over the exigency of service, Lordship, they are directly recruited by the departments.
By direct examination.
Yes, Lord. I think they have a appointed interview was there. Interview. So they did not come through APSC.
But these facts, then they have to be brought on record, whatever
It
we
is a
are.
part of the record. Because what exactly is their case? They want regularization, the case the which my learned friend initially sold. They also entered into the service as on ad hoc basis for 4 months.
Okay.
It was time to time, it was extended because the recruitment process could not be conducted by APSC in spite of our regular request to them.
Alright.
Therefore, we constituted this board. And now we want to hold up.
All I do, bring these facts on record through an affidavit.
Yes, Lordship.
Bring these facts on record through
If
affidavit.
notice be issued, Lordship, I'll place.
Issue notice. Shri Saikya, Advocate General Shri Saikya puts in appearance on behalf of third issue notice. Shri Advocate General Shri Saikya, Learned Advocate General Shri Saikya puts in appearance on behalf of the respondent numbers
State respondents, Lordship.
1, 2, and 1, 2, 3, and 5.
Yes, I don't appear.
So
for
board, you will not be appearing for the board.
Neither for the board I can appear, APSC I cannot appear at this.
Who appears for the commission? Who is the standing counsel?
APSC is there.
You are appearing for the commission. Maybe she'll file an affidavit contrary to what you say.
No, they are more than happy because they are overburdened, Lordship.
You bring these facts on record.
Lordship.
That can be,
Well,
yes,
well, I have a small prayer.
yes,
Pursuant to the advertisement. selection
Recruitment,
process
we
is
are not-
going- No, I'm what I'm saying.
yes.
Let them process with the recruitment, they will not finalize because.
We can
Yes, I
all,
have-
we can only say that the recruitments being made shall be subject to outcome of this
Yes.
petition.
Yes.
It is hereby clarified that recruitments appear for so and so, they pray for and are granted time to file affidavit in a position. Full stop. The recruitments being made as a consequence of the advertisement dated so and so 4622
One second.
4622
Yes, ma'am.
shall remain subject to the outcome of this
Highly object.
writ petition. List on. We would need the pleadings for
Yes,
adjudication.
Lord.
Yes.
So 15th May, if it is convenient,
15th May, yes.
highly obliged.
Let them file by first week, my lord. We'll
We'll
file
file
a
it.
reply.
The counter affidavits in a position be filed by 2nd May. Affidavit in rejoinder, if so required, be filed by 11th May.
My lord.
The matter shall be listed for final disposal at the admission stage on 15th.
Deeply
May.
obliged.
Highly obliged.
Item number 28 of supplementary list for fresh admission which they
Yes.
Your Lordship. My lord, we have challenged the order of the learned single judge, that is page 20, my lord.
Mhm.
My lord, the brief facts of the case is like this.
Yes.
Like this, my lord. There was the election of Fukiragram Cooperative Society Limited in the year 2018.
Mm.
There are the posts of 15 members or directors. Against the 15 posts of directors are there in a society. Now, for general category candidate, there were 12 posts reserved, 12
Yes.
posts, open category. So against those open category, my lord, altogether, my lord, 27 persons submitted their nomination papers.
Yes.
But 14 nomination papers were rejected on various legal grounds.
Yes.
Only 13 nomination papers were accepted against 12 number of posts. Out of this 13, one person has withdrawn his nomination paper.
Yes.
That is on record. So for the post of 12 directors, 12 persons remain in the field. There are two categories of posts are reserved for women. So against these two category of two posts, 3 women candidates submitted their nomination papers.
Sir, you want to continue for 5 more years without facing further elections. That is what your prayer in the writ petition is.
My prayer is this, my lord, we are elected.
Elected for what? What is the tenure?
Tenure is 5 years.
Then how can you
No,
continue
5
beyond
years,
that?
But that committee which was constantly, this pertinent question is this.
We will listen. Don't
In the
worry.
year 2018, the body which were elected,
Yes.
they were not allowed to work.
You could
They
have
were
come.
not allowed to work.
Could have come to the court then.
Before, that is why we came before the honorable court.
In which year?
In the year 2018 itself.
Your writ is of 2018.
No.
Then
First writ petition was filed in that 2429. Then the learned judge on that writ petition asked to continue. That may be seen page 71 and 73.
yes.
To continue the earlier committee. Earlier committee means which was constituted in the year 2013. Not us.
This writ petition is filed by whom?
By
The writ of 2019. Who were the petitioners?
In 2018, these
Yes.
persons were the writ petitioners. In
Yes.
2429, 2018. At the time of motion stage, the Honorable Singhal just said that the earlier committee shall continue. Earlier means which was constituted in the year 2013. So the British authority, it is within Bodoland Territorial Council area. So they took time to file affidavit. But since last 5 years, my lord, they did not file any affidavit. In spite of repeated orders of the Honorable Court. Then in this manner, 5 years have passed.
Just hold on. How can you say that they continued for 5 years? That the direction of 3rd May was only till next date.
Till next day, that was otherwise continued, madam.
Where is the continuance? Where is the order whereby the stay was continued?
Stay was continued, my lord. That order, the next order that is there, but thereafter, my lord, that order was continuing by way of raising no objection by other side. So learned court allowed the earlier committee, which was constituted in the 2013 till the year 2000, till the year this means this till today, that is 31st March. Now, my lord, when the 31st March was coming nearer, then we filed another writ petition.
Yes.
And that writ petition is, my lord, number 76 2023. WPC number 2023. And this Honorable High Court by order, that is page 20, madam. Page 20, operative person, page 26, Lordship may
Yes.
kindly see. Page 26, first order, para 5. Accordingly, writ petition is closed with liberty to the petitioner to submit a
Where is the argument, sir, in this writ petition that you are not allowed to work? Where is the argument?
Yes, that is our whole case, my lord.
Read the argument, sir, before single bench.
My lord, yes, yes.
Yes.
Yeah, I am showing, I am showing. In the writ petition, my lord, I am submitting. My lord, may kindly see page 38, para 7 of the writ. Here, my lord, one thing is to be noted here. The additional register of cooperative societies, my lord, passed an order that 12% should be allowed to cast their vote.
Mr. Mahmood, if you were aggrieved by the direction that the earlier committee was working, you should have challenged that order. Further, you should have filed an appeal then and there.
No, my lord, I have, because when we are not agreed, because our case was kept alive, our right was kept alive.
Can you
and they
tenure?
were asked to file affidavit. My submission I am submitting. my lord.
Yes, please.
Now, my lord, there are the returning officer. The returning officer is the authority to accept the nomination paper or reject the nomination paper, not any other person.
Yes.
But here, Lordship, I invite your Lordship, kindly see the order, page 19, my lord, page 19
Yes.
of the writ petition.
Yes, please.
Here, the order on receiving a petition submitted by Sri Jayanta Sarkar and 6 others, shareholders of Procedural SS Limited, it is observed that their nomination papers were rejected by the departmental returning officer on some very flimsy ground. It is also observed that the incumbents of board of director and secretary of the society perhaps did not give any instruction to the members in relation to filing nomination papers. It is duty of the incumbent board of director and the secretary of the society to give proper guidance to their members, shareholders in the interest of the democratic value of cooperative. Therefore, the nomination papers of 12 members which were rejected by the returning officer on such flimsy ground are hereby accepted. Lordship, kindly see, this order was passed by the additional registrar. He is not the authority. The authority is the returning officer. Now, returning officer may accept the nomination paper or reject it. But here,
Sir, then you were required to challenge this order then and there.
yes, I have challenged.
Then,
I
all
have
right,
challenged.
you have challenged that writ petition is pending. Get that decided in that writ petition.
That was challenged. That is writ petition number 2429.
All right, get that dispute decided in that writ petition. How you can continue? Let us know.
My lord, I am submitting.
Yes.
When we challenge this order of the additional cooperative register of the cooperative societies at Cooperative, then this Honorable High Court passed order, earlier committee will continue. Now we are.
Then you should have challenged that order whereby those persons who are allowed to continue in your place despite your election. You should have challenged that order in DB.
Other party said that we will file affidavit. So.
Who was saying?
The BTC authority says that we.
Why it is your right which were being affected. You were elected. Why didn't you file an appeal?
My right was affected. That is why I was before the Honorable High Court.
All right.
Now, my lord, our submission is this.
Yes.
When a person, Lordship is aware about the election law, my lord. When persons are elected for a particular post, for a particular period,
yes,
they or he should be allowed to function. This is the normal principle of law. Now we are elected, winning certificate was.
Sir, you were required to raise this grievance in the earlier writ petition, not in this writ petition.
That is done, my lord.
When you're so all right, you should have got the writ petition decided, or else you could have challenged the interim order.
The petition could not be decided because 5 years have already elapsed.
All right.
So cooperative society is only for 5 years.
Yes.
5 years have gone. So in such a situation, we filed a second writ petition that yes, the committee which was constituted.
Yes.
My lord, kindly bear with me.
Yeah, of
which
course.
was constituted in 2018.
Yes.
Were not allowed to work.
Yes.
And that was also not granted by the learned single judge in the earlier occasion. So we filed the second writ petition.
Yes.
Lane signature says you cannot work beyond 31st March 2023.
Yes, rightly so.
Now, rightly or wrongly, lordship will decide.
Yes.
But our submission is this, the committee which was constituted in the year 2018, they got no chance.
Mr. Mahmood, it's you who are to fault. You should have challenged that interim order passed in your earlier writ petition, saying that we are elected, you can't allow the whole committee to work beyond their tenure.
At that time, question will be, you are allowed to, your interim prayer, that is, merely subject, how you can file a appeal. So in this.
Yes, why not? Interim orders are daily, every day challenged by
I
filing
know
an
that
appeal.
interim order, if it is in the standard of final order, we may challenge it. We know
Yes,
this.
then.
But thing is this, after all, an elected body was not allowed
All
to
right,
function.
thank you. That's all.
Question of law, this question
All
of
right,
law.
dismissed. Thank you. We are giving you finality this time round. No pendency. Okay, very well.
Problem.
Item number 12 for fresh admission without stay.
Now you complete the supplementary. Don't go like bits and pieces. If you started supplementary, complete it like right away. Don't go in bits and pieces. You change this thing, now complete the main list and then start supplementary. And these bits and pieces we don't like. Yes. Doesn't matter. Supplement is always to be taken after the main list. Yes.
I was required to get some information on the number of teachers who have joined service as an intermediate in the intermediate grade but are drawing greater scale of pay.
This is item number 12. Yes.
But I have got the reports today morning from almost all the districts, around 3 districts remain.
All right.
And we also have to file an affidavit, my lord, bringing on ground as to why they are not actually entitled, but some are getting them. Finance, my lord, also we have to send it to the finance.
So when would you be completing the process?
My lord, give me around 3 weeks time, my lord, I should be able to get the affidavit.
Okay.
My lord, my humble prayer is that, my lord, as some other similarly situated persons are getting, my lord, it is admitted by the other.
That can
So
only
will
be
be
done
granted
finally.
provisionally, my lord.
That can't be done by an interim measure. No? We'll decide that finally. If there is a discrimination, we'll sure take care of the things. All right. Mr. Mazumdar and Standing Council Education Department submits that he has received the details in terms of the order dated 17/2/2023 and is in the process of compiling the same into an affidavit. Mr. B. Gogoi, appearing for the Finance Department, submits that he would also be filing an affidavit within next 2 weeks. The pleadings be completed by next date of hearing, listing. Re-notify on 10th May.
Item number 14.
Yes. Reply. Yes.
May I please, your lordship? The affidavit is sent for vetting, your lordship. The
All right.
affidavit is sent for vetting, your
The
lordship.
affidavit in reply, Land Council MS so submits that affidavit in reply has been sent for vetting. She prays that she may be allowed how much time?
Lordship, matter may list after vacation.
10 days time to file the requisites, file the pleadings list after 10 days.
I'm appearing on behalf of respondent number 4.
Respondent number 4. What about the other respondents? Earlier also the request was for respondent number 4 only by Mr. Nayak. All right.
My lord, I am for respondent number 1.
Do you want file affidavit or what? Or you're not required to do it?
We are not here
You're not the contesting party.
we are respondent number 1. We may follow if any direction is given by my lord.
Do you
We are
want to
not
file
the
affidavit or
implementing
not?
authority. We are not the implementing authority.
All right. You're not the contesting party. All right. Affidavit to be filed within next.
Deeply obliged. Deeply obliged.
Item number 15.
Yes. This is in relation to that details, family details of the earlier family. It's a very logical prayer which is made, Mr. Chaudhary.
Lordship, in fact, I have received the comments from respondent number 4. What they say is
place of, where is the place of birth, Lordship? That is the issue. Place of birth, Lordship. If child can be born in any place. Suppose I am from Guwahati, I was born in Dibrugarh. But that will not include the adoptive parents, that who are the adoptive parents or the adoptive child.
Yes, that's all right. But what is the reason for insisting on the place of birth?
That
What difference does that statistics make? Because what matters is where the person is now residing. The police verification is done from a place where the person currently resides.
permanent place of residence.
Permanent place of residence.
That I'll have to get it clarified, but on the basis of this instructions, Lordship, I can make out a.
So should we decide it on the basis of these instructions?
Come on record, Lordship.
All right, Mr. R.K.D. Chaudhary, DSGI submits that he has received instructions
Respondent number 4.
from respondent number 4 and would be filing the same through an affidavit
Let it be in the first week of May, Lordship.
in next 2 weeks. List on 10th May.
Number 16.
Yes.
May please, my lord. My lord, this was the issue regarding, my lord, notified area has been altered from sports complex to, my lord, that. I have received the instruction, my lord, that it is an NNCPR project of central government, my lord, that the fund was completely not released, my lord. I want to put it on record by way of affidavit, my lord.
How many years? How many years it has taken for the project not to be completed?
My lord, that project, my lord, it was, my lord, sanctioned in the year 2005, my lord. Fund was released in 2005. Thereafter, 2009, second installment was released by the central government. Thereafter, fund was not released.
You let us know the
My lord,
year-to-year progress which has been made.
my lord, thereafter, my lord, subsequently, my lord, thereafter, my lord, special package was granted to the central government by the Custodial Autonomous Council, 26, my lord, stadium, and each stadium having 10 crores, my lord, 260 crores was subsequently granted.
You file a detailed affidavit
My lord,
in reference to the pleadings of the petitioner.
my lord. Only thing is that, my lord, they must maintain the status quo, my lord. Your lordship, I have filed affidavit in
Why status quo?
My lord, they are, my lord, trying to build a auditorium hall.
In place of the state sports
Yes,
complex.
No, my lord, there is nothing, my lord, on that, my lord. That way, I have received the instruction, there is nothing on that. That complex was presently, my lord, occupied by the CRPF, my lord. The CRPF contingency is there. There is nothing is like that way, my lord. We have.
Could we record your statement that there is no proposal to construct an auditorium?
My lord, we will file it by way of affidavit, my lord. I'll file it by way of affidavit.
Then he prays for a stay saying that you are constructing an auditorium.
Lordship, put on the.
And council, Mr. So-and-so, representing the KAC,
KSC, my lord.
response number 6, 7, 9, 10, 11, makes a statement at bar that there is no proposal
At present.
for the present to construct an auditorium on the location of the sports complex.
Defu sports.
Attendance will be marked, don't worry. He prays for some more time to file, bring all the relevant facts on record through an affidavit. List on 17th May. Yes.
Item number 17 for admission with notice served.
Blacklisting.
My lord. My lord, I am challenging the order, my lord, on 2 counts, my lord. First, my lord, I shall place, my lord, but for last 10 years, my lord, we had a drug supplier, my lord, for department. There is no difficulty. Now, this time, my lord, the tender was invited and submitted tender. In the tender, my lord, they issued a corrigendum. My lord, I shall place that corrigendum, my lord, page 103. That is the important, my lord, aspect together.
103.
My lord.
Right. Read, please.
For supply parts, there are some penalty is there, my lord, if no supply. Because of the COVID, my lord, we could not supply. Force majeure is there. Penalty.
But you are given so many extensions,
my lord,
not one.
that is there, my lord. I am on blacklisting, my lord. You will also see, my lord, that penalty in case of quality. My lord, there are 3 penalties. Number 1, your losses in the bottom said, my lord, the chart is there. In case of batch of particular drug item supplied by failed, my lord, some, my lord, withdraw the entire batch remaining so and so. Then second, my lord, next page, my lord, you will also see.
The quality test done by the government or MPNL so-and-so lab tender writing authority. Penalty for
NABL, yes.
so-and-so, these are there. Anyway, number two, that's important now. In case of 3 batches of a particular drug item supplied by the firm, failed quality test, then product department, in addition to the above penalty, the firm shall be debarred from participating in any tender floated by TIA for 3 years for the date of issue of the letter debarment for that item. Now, third, my lord, where the supplier has rep contract for 3 or more drug items, debarred for a minimum of 3 drugs. So, second condition, if it is fulfilled, my lord, then the third penalty is farm department. The farm shall be blacklisted and debarred from participating in any tender of the drug item issued by the TIF for 3 years from the date of intimation. So
you mean to say that only if you are debarred for product department in reference to clause 2,
my lord,
then the blacklisting can come.
then, and secondly, my lord, this is only for a purpose quality, not for supply.
Right.
Now, if you'll also see, my lord, the stockage notice has not been given, but actually, this is not a stockage. If you'll also see, my lord, I'm just at page 122. Here, subject is final stockage notice, my lord, this is there. For to complete the supply of the other drug.
Yes.
Not for any other purpose. Now, in the last portion, my lord, you'll also see at page 123, last paragraph.
Yes.
Therefore, you are given an additional time and final chance to complete the supply within 30 days as you are delayed for more than 250 days from the date of issuing this letter. Else, administrative penalty as well as financial penalty will be levied on your company. As mentioned above referred, tender clause number so-and-so, well, this 5.1.2.3 is also there. Well, so far other penalties are concerned, these are for supply of drugs. That is also another case, my lord, that is different. But this, my lord, 5.1.2.3, this is blacklisting and debarment. This cannot be done, my lord, because this is only in respect of quality. First thing. Secondly, no so-called, my lord, virtually I have not asked to so-called because item number 2 has not been satisfied. The condition precedent has not been satisfied for referring to 5.1.2.3, my lord. So these are the 2 points, my lord. So-called notice, my lord, is a must, my lord. They have to give a proper opposite to me.
Yes, just a lot.
My lord.
This
And
chart, this table you are referring to, that is 5.1.8.
1.8.3, my lord. 0.3. That is, I have referred to, my lord, just first, my lord.
Yes,
That page 103.
Right.
104, my lord.
Just so.
3.
Yes, yes.
So it is the aspect of quality. They have not a single word regarding quality, my lord.
You did not supply, where is the question of
My lord,
quality?
because earlier I supplied for last 9 years, but this year, my lord, we could not supply, my lord, because due to COVID, my lord, the persons went there. Even the
Consignments
government has issued circulars, my lord, now for listening. But that is another aspect of matter. That's
Yes.
which I'm not before lordship. I'm only in aspect of this penalty, my lord.
Right. So the
So
heading
now-
of the notice, as per you,
Yes,
the heading of the notice was non-supply.
not, my lord. Any of the notice, not so, my lord, because I have not asked to so-called, my lord. Because first thing, the penalty first can be imposed only condition precedent to be satisfied. That condition precedent has not satisfied. And secondly, my lord, your losses, no, my lord, the latest judgment I can just refer to, my lord, 21.2 for my lord regarding. Because some judgments are there, my lord, even Supreme Court goes to the extent that hearing should be given. Because this is a
Blacklisting.
and but some other judgments say, my lord, that no, my lord, at least, my lord, here, my lord, in this judgment, my lord, I shall refer to para 13, 14, 15, my lord, and others are also there. 16, 17, my lord. It's a lawsuit, see, my lord, page 558, para 13 onwards, my lord.
Yes.
At the outset, it must be noted that it's a first principle of civilized jurisprudence that a person against whom any action is sought to be taken or whose right or interest are being affected should be given a general opportunity to defend himself. The basic principle of justice is that before adjudication starts, the authority concerned should be given to the affected party a notice of the case against him so that he can defend himself. Such notice should be adequate and the grounds necessitated action and the penalty action proposed should be mentioned specifically and unambiguously. An order traveling beyond the bounds of the notice is impermissible without jurisdiction to that extent. In this court in Asirab and so held that the essential for the notice to specify the particular grounds on basis of which an action is proposed to be taken so as to enable the notice to answer the case against him. If these conditions are not satisfied, the person cannot be said to be granted as an opportunity of being heard. Especially in case of blacklisting, a person or entity by the state or state corporation, the requirement of a valid, particularized, and unambiguous so-called notice is particularly crucial due to the severe consequences.
Wait. Yes, 5.1.2.3. Debarment of 3 drugs.
Yes, my lord.
Then only the blacklisting is permissible.
Lordship, here, my lord, we have exercised, my lord, 5.6.3.
6.3.
Lordship.
There is a show cause notice in reference to that. Let us see.
But, my lord, in the notice, my lord, it is only 5.6.2, admittedly, my lord.
Then 5 point?
6.2. Lordship will find.
No,
page-
5.1.8.2. Read
No, no.
page 123.
No, page 122, Lordship.
Yes, read. Debarment.
Delivery, shortage and delay penalty.
Oh, that is delay penalty. Debarment we are talking about.
Lordship.
5.1.8.2. Page 123.
3.
5.18.2, my lord.
Yes, 18.2. Yes. What does that say? What is that clause?
My lord, that
Refers
was
to-
again quoted at 123 also, my lord. 123 middle.
Yes, that is what we are referring to.
Yes, ma'am.
That clause deals with first debarment of 3 particular drugs, which would have the cascading effect of blacklisting.
Lordship.
So there is no debarment of 3 particular failed drugs. That is relating to quality.
Lordship.
You are not on quality, you are on non-supply.
Non-supply.
Non-supply, obviously, everyone knows there was a serious crunch in supply of drugs during COVID. Everyone was running.
More than, my lord, about a year was given, my lord.
Come what may, does your tender condition contemplate debarment on this?
Yes, my lord, Lordship may kindly see that, that's why, my lord, 5.6.3, page 97.
5.6.3,
Yes, my lord.
97. Yes.
It's, my lord, 5.6.3, the order stands cancelled after the expiration of delivery period, and if the extension is not granted with or without liquidated damage, apart from risks alternate purchase action, the bidder shall also suffer forfeiture of his performance security and shall invite other penal action like blacklisting,
So, all right, you have to give him a notice of 5.6.3.
Yes.
Have you given that notice?
Probably, my lord, that 5.6.3 is not mentioned, my lord.
So,
specifically.
then
Otherwise, my lord,
what is the heading of your notice? Non-supply only.
Lordship.
How do you sustain?
My lord, 5.18.3, my lord.
So 5.18.3 does not apply.
Misplaced, otherwise misplaced.
It's totally misplaced.
Lordship.
What does the Learned Single Judge say?
This point has not been considered by.
This has not been considered. Was this a ground?
My lord.
Was this a ground in your pleadings?
My lord, if your ground, my lord, page 15, you'll have to see, my lord.
Mm.
No, in the repetition.
Mm.
Appeal also is in Roman 3, my lord, that is there.
Ground number 3.
Yes.
Page number?
5.18.2.3 quoted here in below clearly stipulate that where a supplier of head contact for 3 or more drug items
All right.
can depart for a minimum of 3 drugs. In that case,
All
only
right.
the farm can be blacklisted and depart.
Okay, we'll pass the order.
And in
Dispose.
that case, my lord, one thing, my lord, may I pray that, my lord, Lordship will give us the liberty to, my lord, take, if necessary, to take action as per the appropriate provision, my lord. That liberty may be
What
there.
prevented you from doing so earlier?
My lord?
What prevented you from doing so earlier? You should have withdrawn the order immediately on receiving the copy of the writ. Seeking liberty, reserving your right to proceed against the supplier. Why did you do so?
But admittedly, my lord, he has not supplied, my lord. After all, my lord. the
Mr.
state has
Counsel,
supplied.
the writing was on the wall. There is a specific ground in the writ petition.
Lordship.
You were there to oppose. Why didn't you advise your client withdraw the order? It's apparently illegal.
My lord, the ground that has been now placed is, my lord, ground in the writ appeal, not in the writ petition. Let me prove, my lord, in the writ petition, my lord, subject to.
Are you sure that argument is there? That argument is there. Mr. Saiwala,
Yes.
read out from the writ petition, please. In writ petition, probably this ground is not there.
That's why I'm saying.
That I have argued, my lord.
Maybe the
Yeah,
ground is not
I'm
there.
coming, my lord.
Because I was
I'm
the
coming,
councilman at that time, my lord, when it was actually the Backdoor meeting.
All right.
My lord.
So we'll give them that liberty, Mr. Saiwala.
Lordship, lordship.
That will give you another shot at filing one more petition on behalf of your client.
My lord.
That will give you one more chance of getting one more brief.
My lord.
All right. So, dispose of. We will decide.
Matter number 18.
Yes.
In this case, the sale and the surface was challenged, my lord. And lordship, after going to pleadings, my lord, directed the respondent will keep the records. Bring the records will the perusal of this on court, my lord. What happened, your lordship wanted to see, my lord, as to when the auctions actually took place, my lord, the sale took place, my lord. Because our case was, my lord, that when we approached, my lord, the auction notice was in January 2022, my lord. Thereafter, in the month of May, my lord, we approached them, my lord, saying that we want to settle the matter. Then they said that we are not settling the matter because the matter is pending for the DRT. My lord, considering the fact that, my lord, they had my lord, not informing us that there was a sale process in the meanwhile, my lord, initiated, or that there was a bidder pursuant to that auction. But when in January, my lord, we submitted another representation, my lord, saying that we want to settle the matter, they said the property has already been sold. So therefore, your lordship wanted to see, my lord, exactly when the bids were received, my lord, and when it was sold, my lord.
My lord, the engaged counsel was medically unfit and was in hospital, so kindly allow some time.
Who is the engaged counsel? Mr. Banerjee.
Banerjee.
It's stated that arguing counsel, Mr. D. Banerjee, is unwell today. And thus the matter may be adjourned for the present. Or list again on 4th May.
Obliged.
Obliged.
Now you can call the remaining supplementary. Before hearing, you can call the supplementary. Yes. Is there anything left? If there is one matter, yes.
Item number 29 of supplementary list.
My lord, I appeal to the appellant in this matter. Your lordship, this is an appeal against the order of the Honorable Single Judge wherein the notification of 1965 was caused, but deed was quashed. According to the notification, your lordship, the half a mile of both sides of 14 rivers were declared as reserved forest.
Okay.
Now thereafter, your lordship, my lord was pleased to grant a stay till the disposal of the application.
All right.
My lord, I shall point my lords out certain pages of my application.
Application,
Main app,
writ appeal or application?
the writ appeal.
My lord, I have filed impleadment petition, my lord,
Impleadment,
for impleadment petition and NHI.
NHI.
Listed along with this writ appeal, my lord. Today is this matter also fixed for impleadment petition. And my learned friend submitted, given me one reply also. This is a lordship information. May I apply the facts only and the list of date?
Whether your impleadment application has been decided, it has, you've been impleaded already.
No, it is, I leave application was granted because I was neither party in writ petition or earlier petition. That is I am being aggrieved by letter dated 13 January 2023. When it's after passing status quo order by this honorable court. Here, that letter was said to return to me by the Undersecretary of the Mizoram that you stop your work, construction, as there is a status quo order in writ appeal, present writ appeal, my lord. Thereafter only I am being aggrieved. Thereafter I have come. As I was neither in writ petition, I have prayed for leave application. Your leave lordship was kind enough to grant allowed to leave for filing impleadment. Today, impleadment petition is there. Here, my lord, only kind of lordship for a petition only list of dates. That is from particularly, my lord, date of judgment passed by honorable single judge until date of status quo order. What progress was there? That is because why I am being affected, my lord. That lordship may peruse kindly before going ahead of this one, my implementation only first go file in Excise 11, page 259, my lord. That letter will say why I am before your lordship.
What do you say to the impleement application, madam?
Lordship, with permission, I have what I have understood because I have studied a hard edition. Paragraph section 7, she, my learned friend stated that regarding this, you do not have any objection. And I said, no, it is a delay. He is putting some condition. That is why it is up to your lordship. Lordship may pay. Now my submission is this one, why I am before lordship. And I have given list of dates. And list of text this one. Up to status quo order, I have paid 280 crores, 280 crores to the affected parties, the landowners, below. In terms of direction of Mizoram government as well as competent authority of land acquisition.
Well, all right, you have not started the construction. That is true. That is so.
No, we have started.
There is an issue of a reserve forest, Mr. Council. Issue of a reserve forest. We have to be very sensitive about that.
That is why,
Yes.
my lord. That is why I want to reply in detail. Today I am not on. I am putting on.
All right, what do you say to the implement application?
Application only today.
My lord, whether the forest is reserved or not, the forest was a forest from time immemorial.
Yes.
My lord knows better than me, your lordship, as per the Godavaran judgment, your lordship, the forest.
We understand. Today, madam, we are only on the implement application. What do you say to that?
Why they should not be impleted is that, your lordship, they do not have any forest clearance. Whether it is a reserved forest or not, a forest clearance is needed. Now,
So let us hear them. Then we'll pass the order whether they are having a clearance or not, whether they can proceed with the construction.
I'm ready for the hearing. Your lordship. If they want to proceed
They
with
would file affidavit thereafter. They would be required to bring on record their pleadings. All right. IA number so and so has been filed by NHIDCL seeking implement as a party in this writ appeal, and counsel representing the appellant does not object to the prayer for implement. Hence, otherwise also, in the opinion of this court, since the corporation has been granted a project for construction of highway on the disputed chunk of land, it would be essential to hear them before passing any order in this appeal. Thus, the implement application is allowed. NHIDCL, applicant NHIDCL is implemented as a party in the writ appeal.
82 and 683.
Writ appeal number so and so and so and so.
Number 683.
The respondents number so and so.
Yes, and writ appeal number 7420.
Necessary amendment be made in the cost title. Affidavit, if so required, on behalf of the corporation may be filed within next 4 weeks. Please thereafter.
Maybe
Madam,
shorten. Maybe
fix a
shorten. I'll
date,
give
your
before that.
lordship, kindly.
Before that, I'll give because my
It's okay. Yes, Mr. Kali. Mr. Kalita, an additional court general appearing for the state of Mizoram may also file additional affidavit if so required. List on 24th of May.
My lord.
Take it now. Take it now. Yes. You can proceed with the admission of the main list till hearing, then take up the supplement. There's no difficulty. It need not break and unnecessary.
Item number 6, time being matter.
Yes.
Well, the affidavit on behalf of the respondent number 2 is on record, Malad. Okay. Lordship may kindly come to paragraph 4, Malad. Malad, in terms of the direction of the honorable court, I'm reading paragraph 4, Malad. In terms of the direction of the
Who is for the petitioner? Who is for the petitioner?
Malad, the petitioner, Mr. Sharma, was there, Malad. I have given him copy.
All right.
Lordship.
Mr. Nath has filed the affidavit in opposition of the respondent number
2, Malad.
2. Copy thereof has been provided to the petitioner's counsel, who prays for time to complete his instructions. List after 1 week.
Item number 20 for hearing.
Lord, the matter relates to refund of my lord central excise duty. Now, Lordship knows there is a package of incentives for units setting up industrial units in Northeast India and some other parts. of the
Refund or refund, interest on refund? What is the issue?
No, my lord.
Claim for refund only.
Refund.
All right,
We are agreed by the denial of refund for a particular period.
all right.
Now, my lord, if I read one order, it's a short order, Lordship will get the facts, my lord.
Sure, sure.
Before that, I'll place the two notification based on which we are claiming this benefit.
Just.
My lord, initially the notification was issued in 1997, but over a period of time, various amendments were made. That is how at page 13, my lord.
Page 13.
13,
25/4/2007.
my lord. Now, if I lordships may kindly come to paragraph 3. The exemption contained in this notification shall be given effect to in the following manner. The manufacturer shall submit a statement of duty paid other than the amount of duty paid by utilization of Sandwich credit under the Sandwich credit rules of 2004 to the Assistant Commissioner or the Deputy Commissioner of Central Excise as the case may be. By the 7th of the next month in his duty has been paid other than the amount of duty paid by utilization of Sandwich credit under Sandwich credit rules of 2004.
So the issue is regarding delay.
Yes.
Delay in filing the claim.
Yes.
Yes.
The
All right.
Assistant Commissioner of Central Excise or Deputy Commissioner of Central Excise, as the case may be, after such verification as may be deemed necessary, shall refund the amount of duty paid other than the amount of duty paid by your utilization of Sandwich credit under the Sandwich credit rules during the month under consideration to the manufacturer by 15th of the next month.
Right.
Now see, if there is likelihood of any delay in verification, Assistant Commissioner of Central Excise or Deputy Commissioner of Central Excise as the case may be, shall refund the amount on the provisional basis by 15th of the next month to the month under consideration and thereafter may adjust the amount of refund by such amount as may be necessary.
So this is an ongoing process.
Ongoing process, my lord. In fact, my lord, there is a procedure called self-removal procedure, which all these SSCs adopt, my lord. In fact, my lord, I'll show how there, my lord, misconstrued the whole notification. Please come to page 15, my lord. 6. Oh, sorry. 5A.
Yes.
No, we are not concerned. 6. The exemption contained is notification shall apply to any of the units for a period not exceeding 10 years from the date of publication of this notification or from the date of commencement of commercial production, whichever is later. So benefit one is entitled to for 10 years from the date of the notification or from the date of commencement of commercial production. Well, this notification was substituted, some amendments were made, which your lordships will get at page 17. And the operative portion is at page 18.
Yes.
Now that this is very crucial, my lord. 4. Now the para 3 is substituted by the following. In case the total amount of refund paid or payable to the manufacturer in respect of the goods cleared from a unit during a financial year is less than the total duty paid by him on the said goods, other than the amount paid by utilization of Sandwich credit for the year, the differential amount, if any, shall be refunded to him, subject to the condition that the total refund made to him during the year, including the aforesaid differential amount, does not exceed the total duty payable on value addition, whether at the rate specified in the tables or at the special rate fixed under paragraph 9. In other words, my lord, on value addition, they will be entitled. Number 2, the Assistant Commissioner of the Central Excise or Deputy Commissioner of Central Excise, as the case may be, shall refund the differential amount, if any, to the manufacturer not later than 15th day of the May in the subsequent year. So, my lord, I think the concept of delay gets, my lord, diluted here. Now, my lord will kindly come to page 21. This is the impugn order where lordship will get all the facts. Only 2 pages, my lord. Now, I'll read from para 3.
Yes.
From documents submitted, it is observed that total duty paid on the finished goods during the aforementioned month and refund claims are as given below. As the SSC has submitted application for eligibility on 8/1/2012 and subsequently submitted refund claim in a lot on 15/3/12 by their lettered number so and so, the SSC's claim for refund for the period during January 12 have not been taken for consideration on the ground of violation of provisions of clause 3 of the notification dated 25/4/2007. However, as the SSC has deposited central excise duty for the month of January 12 and February 12 by each Alan so and so, and as per request of the SSC by later dated so and so, refund application for the month of January and February have been taken into for consideration. The SSC's claim for eligibility to exemption by a refund in terms of notification dated 25/4/07 as amended has been physically examined by the Assistant Commissioner of Central Excise Nagaon on 9/2/12 with reference to SSC's application dated 8/1/2012 and found eligible for refund of the Central Excise duty in terms of the notification dated so and so as amended. It's a new unit and its installed capacity is found to be 50,000 metric ton per annum. The SSC has claimed refund in terms of notification dated so and so and so and so as amended have been examined. I have verified and found that the unit has started commercial production with effect from 12/7/2010. A reliance is placed on daily stock account of the SSC and verification report of the jurisdictional range superintendent. Since exemption in terms of the notification dated 25/4/07 and 10/6/2008 as amended is available to a unit from the date of issue of the said notification or from the date of commencement of commercial production, whichever is later, exemption is available to the unit of the SSC for a period not exceeding 10 years with effect from 12th of July in terms of para so and so. I have caused verification of the records, such as statement of duty paid. This is very important. PLA, GR, Chalan, ER for the relevant period, and verification report of the jurisdictional superintendent of the SSC relating to their claim of refund, production, clearance of goods, and payment of duty through account current as well as send with credit. However, I observed that notification dated 27/3/08 and 10/6 so and so as amended provides that admissible refund in terms of notification dated 10/6/08 as amended shall be the amount of duty payable on value addition undertaken in manufacture of excisable goods by the claimant. The SSC's clearance of finished goods and utilization of raw material in respective months have been shown in the table. As the SSC has applied for eligibility for refund of excise duty under notification dated 25/4/2007 by their application dated 8/1/12 and subsequently submitted the refund claims in a lot from July 2010 to February 2012 on 15/3/2012, refund for the months other than January 12 and February 12 cannot be sanctioned and rejectable on the ground that the application for eligibility was submitted only on 8/1/2012 and refund claims were submitted on 15/3/2012 in lot for months from July 2010 to February 2012. And as the SSC has violated the provisions of clause 3A of the notification dated so and so. In view of the next page, my lord, in view of the above, it is found that an SSC is eligible for the refund of excise duty paid by them during the month of January and February in terms of notification dated so and so. In view of above, I reject the refund claim for the month of July 10 to August so and so, so and so. And for other than 2 months, it was rejected. Now, my lord, let us come to 5A, 3A. What is the requirement at page 13, my lord? What is the requirement of making separate application or my lord applying?
The requirement is to file the application within the stipulated period
No,
from the accrual of the.
yes. No, my lord, it operates like this, my lord. Supposing I clear goods worth 1 lakh in a month. But by 7th of next month, my lord, I'll submit a statement, which I did, which they admit also. So my lord, a similar point on similar issue, there's a judgment of this division bench judgment, my lord, where it is said the procedural part will not come in the way. The substantive right of refund will prevail. And I'll come to that, man. Kindly see the 3A. Manufacturer shall submit a statement of duty paid other than the amount of duty paid by students. So what is the requirement envisaged in 3A?
Statement of duty paid.
Yes. Now, please come to my lord, page 22. Para 7. I have caused verification of the record such as statement of duty paid. Whereas he said that from the statement that I have not made the statement of duty paid. But these are all technical, my lord. But there is no dispute. My lord will kindly take note of few dates, my lord. 12/7/2010, that is the date of commencement of commercial production. 12/7/2010.
Just a moment.
My lord.
Where is the procedure for filing the application?
There is no other procedure other than 3A, my lord. My lord, I am eligible unit from an anterior date. And I'm submitting
But they
statement.
say that your claim was filed in 2012.
Yes, I submitted it a lot. But my lord, my eligibility was given by them only.
So there is no, as such, there is no procedure for filing the
No, my
application
lord,
for refund.
Nothing. That's what I'm saying. It only says manufacturer shall submit a statement of duty paid. That which I did, which the jurisdictional deputy commissioner has taken note of. So what more is required?
Is there any observation in any of the orders?
Yes.
That the statement of duty paid was furnished beyond the date?
Yes.
Where is that?
I think my lord is there. I think my lord at page 22 itself, para 9, my lord.
Let's see, sir.
As the SSC has applied for eligibility for refund of excise duty under notification.
This is eligibility.
Yes.
We are talking
they
about
have not made
statement of duty paid.
No, my lord, this is the original adjudication order. Then I filed 2 appeal, one before the commissioner appeal and state. They have dealt with in a similar fashion.
Is there any prescribed format for the refund claims?
No, my lord. There is no prescribed.
Mr. KL,
It is there.
where is it?
That is.
All right, we will, if required, will you call you back?
Yes.
Read out from this notification, what is the format or what is the procedure for filing claims?
Not so basically paragraph 3A.
Read, where does it say that claim has to be filed?
The manufacturer says submit a statement of duty.
Duty paid, all right.
Other than the amount of duty paid by utilization of sandbed credit under
Yes.
sandbed credit rule 2004. To the assistant commissioner or the deputy commissioner of the central excise, as the case may be, by 7th of next month.
So where does your order indicate that the statement of duty paid was not presented within that date?
Lordship, it is there on statement. Lordship,
Sir, please read from your order. Statement of duty paid was not filed within the stipulated period.
Yes, Lordship.
Read, please. Your entitlement is not disputed, Mr. KL.
No, entitlement is not disputed.
The government wants to be unduly enriched. Enriched or what?
This honorable court on 2 occasions dealt with same issue and passed order, Lordship. I am discussing that.
Let us see.
Same issue.
Let us see. Let us see.
This is to the
Read. Please give.
to Justice Chaya or something.
Let us see.
Same issue, Lordship.
Let's see.
There was a delay.
Delay in what?
In filing the.
Sir, we are asking you where is there is a requirement of filing a claim. This is an automated system.
Yes.
He files the statement of duty paid, you make a refund.
Lordship, they have to file within seven days of each month.
Now that is where the shoe pinches. Where is the finding in your order that the statement of duty paid was not submitted in time?
Lordship, paragraph 9.
Read.
9.
Before that, read para 7.
Yes, Lord.
Your order reads about statement of duty paid only at para 7. Para 9 deals with his prayer for refund.
No, Lordship, yes, Lordship. Lordship, see, when they file. The requirement?
Where is the requirement?
No, Lordship, 3A is the language is very clear.
Language is very clear. Statement of duty filed, duty paid.
But when they claimed, it is there admitted.
Yes, sir. He only says, I have paid this much of duty. Now the responsibility is on you to make the refund.
Lordship, the syndicate rule, Lordship specifically said they have to apply for the refund, Lordship.
Read.
Lordship rule is not with me at this stage, Lordship.
The refund is in a special set of circumstances.
No, Lordship, please to see.
Is a Senvet credit is not being refunded.
No, Lordship. The
Senvet credit, what they have utilized is not being refunded.
is to be deducted
So
in fact. No,
that will be deducted.
no, Lordship, for applying that, they have to file application, Lordship. The prescribed format is there.
Format, does the format says that it has to be in a particular time?
Yes, Lordship, because it's.
Read, no, please read. Read. Where from are you arguing this?
Lordship, I'm reading again, page 13.
Yes, read.
Subclause.
Mr.
A,
KL,
3.
Mr. KL, just let's draw an analogy. You furnish an income tax return.
Lordship.
Are you required to file a separate application for refund?
Lordship, every year I have to file my return within a specific.
Within a specified time.
Yes, Lordship.
So he has to submit a statement of duty paid within a stipulated time. Refund is automatic.
Lordship, he has not filed that within 7th of every month, Lord.
Sorry.
If that is there.
If that is so, you point out from your documents
No,
that
Lordship.
he did not furnish the statement of duty paid within stipulated time.
Lordship.
Then he is out of the court.
No, I want to draw your attention to paragraph 9. May I read, Lordship? Page 22.
Yes, please read again.
Yes, yes, Lord.
Let us be benefited by that again.
As the SEC has applied for eligibility for the refund of excise duty under notification number so and so by their application dated 8/1/12.
Mr. KL, let us again read 3A, please.
Then
Let us read 3A again.
no, Lordship, I'll come to that, Lordship. Thereafter the two.
Let us read 3A first.
Yes, Lord.
Again.
As the
Does it contemplate filing of a refund application? Please
Lordship, I'm married.
read.
As the manufacturer shall submit a statement of the duty paid other than the amount of duty paid by utilization of Sandwich credit under the Sandwich credit rule 2004 to the assistant commissioner
Yes.
or the deputy commissioner of the central excise as
Yes.
this may be by the 7th of next month, which the duty has been paid other than the amount of duty paid by utilization of Sandwich credit
Yes.
under the Sandwich credit rule 2004.
All right. Now, what is the consequence of the statement being filed?
If they
Read,
have
read.
not filed, then they cannot claim the exemption, Lordship.
Oh, just a minute, sir.
Lordship.
What is the consequence of the statement of duty paid being furnished? The consequence is provided in B.
Yes, Lordship.
All right.
Yes, Lord.
And the consequence is automatic. And now we would go further and say that because you have not acted as per clause B, despite the statement being furnished, why shouldn't they be awarded interest on delay in refund?
No, that is already, the issue has already been pending before the Supreme Court on last occasion. Lordship has directed us to pay amount that will be subject to the outcome of the Supreme Court judgment.
Yes.
But here,
Here, where does this notification wherein this exemption is provided or refund is provided, exemption from payment of duty is provided,
Yes.
where does this notification contemplate filing of a formal application?
Lordship, in my humble submission, they have to apply within 7 days of each month.
Please read from your notification, sir. What is to be filed before 7th?
That not claiming exemption.
Mr. KL, read from the notification, please. We expect something better from you.
Then Lordship, B.
Yes, B. Once he filed the SSC files the statement of duty paid, the onus comes on you. Make a refund
Lordship,
by 15th.
In my humble submission, for that period that was filed in 2012, they are claiming exemption for 2010 to 2012.
Mr. KL, you're confusing. Is it your case that the statement of duty paid was filed after delay?
Yes, this is my.
Where is your reply? Let us see. That statement of duty paid was also filed after delay. Point out from your pleadings and then he has no case.
I'll open the original record, Lordship.
It's your own order.
No, Lordship. Lordship.
Read para 7 again.
Paragraph 9.
Para 7, please.
I have proposed verification of the record. Such a statement of duty paid PLA. GAR
Duty
7
paid for the relevant period
relevant
and
period,
the verification report.
of
So, Mr.
jurisdiction.
Mr. Kale, Mr. Chaudhary, now one question to you.
Yes, madam.
If the statement of duty paid was delayed,
Yes.
is there any consequence provided?
No, my lord. That is also not provided. My lord, in Hansraj Gordhan Das Supreme Court said, my lord,
Yes.
it is the duty of the taxpayer to show that he comes within the four corners of the notification. Then the burden is upon him. My lord, my learned friend has not taken note of one thing. My eligibility was adjusted only in 2012. That's why, my lord, the process started late.
Eligibility was adjusted
Yes,
for what reason?
No, my lord, it works like this. I applied, my lord, I applied for eligibility on 8/1/12 and it was done on 9/12/12.
So, but if your statement of duty was submitted
It
in
was
time,
going on.
your claim would not have been defeated
No,
on that ground.
because my entitlement is either from 10 years from the date of the notification or from the date of commencement of commercial.
Yes.
And
Mr. Kale,
commencement
your
of,
para 7 makes it clear.
yes.
The statement of duty paid has been verified.
Lordship may come to page 41 of the CSET's order, Lordship. 41.
Oh, yes, read.
Paragraph 3.
Yes, please.
Although clause 3(1) has been quoted here.
Yes.
For the proper appreciation of the case, clause 3A of the notification number so-and-so is reproduced. Then, on plain reading of para 3A of the said notification, it is clear that
Again, there's total misunderstanding of the provision. The SSC is only required to furnish the statement of duty paid. That is an intimation to the jurisdictional authority that I have paid the duty on time. And the consequential excise is to be done by the authority. Now, he may have been delayed in filing the application because he acquired the eligibility documents later. But what is crucial is that the duty should be paid on time and the statement should be conveyed. That is all what your notification requires.
and Lordship, this honorable court clarifies this position.
Let us see.
in that
Let us see whether the
Paragraph-
court takes note of this clause,
Yes, Lord.
what the clause requires.
Yes, Lordship.
Yes,
They can come, Lordship may come to paragraph 9.
yes. Read.
A perusal of the pleading, including reply dated so-and-so by the appellant before the authority concerned, reveal that such procedure is prescribed in notification 33 of 2099. Same.
Para 9. You're reading
19. 19, Lordship. I provided copy, Lordship. It is
Uh,
dated 8.
Lukwa Tea Estate.
Lordship, Lakwat Estate.
Lukwa. Yes, para
19.
19. Yes.
The perusal of the pleading, including the reply dated 8/2009 filed by the appellant before the authority concerned, reveal that such procedure as prescribed in notification 33 of 99 has not been followed by the appellant SSC.
Although in the show cause reply, it is stated that RT returns were regularly filed, but there is no statement as to whether the RT 12 return filed by the SSC satisfied the requirement of filing a statement. No, it is not your case. Your order says the statement of duty paid has been verified. Verified means verified as per requirements of the notification.
Lordship, further, I want to submit, Lordship, paragraph 9.
Don't worry, we are not shutting you out from arguing, but satisfy us on this.
Lordship, definitely.
This judgment does not apply.
Lordship, further, Lordship.
Yes. Is this judgment dealing with the notification of 2007?
Lordship,
Mr. Kale,
99 was similar provision was there.
specific notification. The language of notification seems to be distinct.
33 is same language, Lordship.
Read, where is it?
Lordship.
Question is
it's a
delayed interest on delayed refund.
Lordship, paragraph 23, Lordship.
Or question number C, please, para 3.
Paragraph.
Para 3. Question number 3. Delayed refund and interest. Para 3C.
In that case, their claim was also rejected, like this, Lordship.
The question of law doesn't say so. Question of law says whether the appellant is entitled to get interest for delayed refund.
Lordship, paragraph 3A, Lordship.
Yeah.
Whether the order of the tribunal, CSET Calcutta, rejecting the appellant's exemption claim under notification 33 of 99
Yes.
is barred by principle of res judicata as the same issued allowing the exemption benefit to the applicant has already been decided by the
Yes.
Honorable High Court in judgment dated so and so so and so. So in my humble submission, same question of law is here, Lordship.
All right.
But we come to paragraph 23.
23.
Insofar as the substantial question of law is concerned, it is held that the requirement under exemption notification 33 of 99 is that the manufacturer shall submit a statement of duty from the said account current to the assistant commissioner or deputy commissioner as the case may be.
All right, come to para 18. That would make things clear.
Yes,
para 18, please. This court also says that the claim is to be laid by filing the statement of duty.
Yes.
Which there is no dispute.
Paragraph 8.
Yes.
In view of the such procedure.
The judgment goes against you.
Under the clause 2A of the said notification, it
Yes.
is clear that the refund are to be claimed by filing an
Statement of duty. No separate claim is to be filed.
paid to the Lord. Here, Lordship, they are filed in 2012, Lordship.
Oh, gentlemen, please, you are confusing. That is a formal application. Please make the refund because you did not act as per clause B. They were only required. Please read the para completely.
Yes.
What is the claim of what is the claim application? What is the format?
The assistant commissioner or the deputy commissioner of the center is required to make such verification as deemed necessary before any refund duties pay is made. The notification also provides for making refund on provisional basis by 15th of next month.
Yes.
Thereafter, adjust the amount of refund, such amount as may be necessary in subsequent refund admissible to the manufacturer.
All right. Now, para 19 says that there is no evidence that the
Yes.
RT 12 returns, that is the statement of duty, was filed in time. Herein there is no dispute.
But in paragraph 7, only said that they can be verified. So we can presume that it was verified after filing of their application in 2012, Lordship.
How can we presume that?
Then,
Because your clause A says has to be filed by 7th day of every month.
Yes.
So if it was verified, we can presume that they were done
No,
as
Lordship.
per the statute.
Then, Lordship, the petitioner is to show if they have filed within the 7 days of every month.
Why is the petitioner required to say, you say that you have verified it?
No, Lordship, but the period is not, and Lordship, my humble submission in paragraph 7.
These are statutes which are required to be interpreted strictly.
Yes, Lord.
And when you, while applying the statute, your jurisdictional authority says verified. Verified means as per requirements of statute or the notification. We can't read anything else in that.
No, Lordship.
Otherwise, your authority would have clearly said the returns were filed beyond time.
No, Lordship, in my humble submission, it is not there, I think. Lordship, paragraph 7.
Yes, read it again for your satisfaction. We are very clear in our mind now. Yes. His application, the application of the party doesn't say that we are filing statements now. They only say that we are now filing our eligibility proof.
Lordship, paragraph 3, Lordship.
Yes.
Page 21.
Yes.
As the SSC has submitted application for eligibility on 8/1/2012.
Eligibility.
Lordship.
That is not even a claim.
Lordship,
Yes.
there, and subsequently submitted refund claim in lot on 15/3/2012. Lordship.
So there must be some criterion for eligibility.
No,
But
eligibility, Lordship, there is no dispute. Lordship.
so that's what we are saying. If that is not disputed, then his claim has to be considered in reference to the date of the statement of duty paid. That is all.
That was filed in 2012. Lordship.
Where does your order refer to statement of duty paid? Read that part.
Yeah. 2000. Lordship, paragraph 1. Paragraph 1, last 3 lines.
1. Read.
They are availing the exemption of central excise duty in terms of notification 2007 and notification dated number 30/2012 as amended in claiming refund.
The refund of excise duty paid in account current in respect of their final product with effect from July 10 to 2012. Now, if at all they had not paid the duty and they had not provided you the statement, the natural consequence would have been your authority would have stated no statements filed. That is not your case.
No, that is, in so many words, it is not there.
And so many, and on the contrary, para 7 affirms their contention that statement was filed in time. Thank you.
In my humble submission, that.
We'll take note of your argument, of course.
No.
Yes.
Exactly on the same point, a division bench of this honorable court, my lord, while dealing with this similar provision in the predecessor provision, my lord. I'm sorry, my lord, I'm holding one copy.
No issues, no issues. Please.
No, Dr. will kindly have a look at para 8 and 9.
Yes.
Para 8 and 9. This honorable court has said, my lords, there is no requirement of filing application.
That would make the things clear.
Para 8 and 9, my lord. Para 8 is the similar provision and 9 is the finding.
Yes, that is what
That's the point.
we are talking about.
And Lordship,
Yes.
another submission.
First read this judgment. Thereafter
Yes,
submissions will
There,
consider.
there come, there.
You have got the judgment?
I've got the judgment, Lordship, 2013 jail.
Yes, yes. 2018.
18. It was Ajit Singh or Manjit Singh.
Yellow. Then on.
Vanapur T state.
These things, this judgment makes the things clear.
Lordship, another submission for consideration by Lordship.
Yes.
Their claim for 2 months was allowed. It was filed along with the earlier claims, Lordship. And since they doesn't.
So you will be required to pay interest only on the previous unpaid claim.
No, Lordship, that is different question of law. Whether.
All right,
since the
all
claim
right.
was Rejected, Lordship is allowing today. So obviously. That will
The
be
interest component will be paid.
No, Lordship, from the date of when the Lordship is allowed their claim.
Wrongful denial.
No, that is Lordship, whatever Lordship says, that will follow, Lordship. I cannot comment. That is
No. What do you say about interest? They are not claiming.
Two-way traffic, my lord.
Mrs. Chaudhary is not claiming because interest would lead to a SLP being filed.
And that is already covered by, will be covered by the Supreme Court judgment. Whatever it may be on our favor. or against
Yeah.
us.
The amalgamated tea plantation, this honorable court has a passed order for payment of interest also.
Yes, that has already been challenged before Supreme
And
Court.
my lord, subsequently, Supreme Court has clarified, my lord, this is not a refund under 11B. It's a refund because of this industrial incentive.
Yes, incentive.
Because some people are coming, setting up industry in this, my lord, backward area. Therefore, this is how, my lord, it operates. It's a different regime altogether.
Yes, yes.
And Lordship, please note that they filed their claim for 2010.
Mr. KL, please read the judgment, then you don't even, you are not required to make that argument. There is no such procedure as filing a claim in your notification. Notification has automatic consequences that you just provide us the statement of duty will make you the refund. That's all.
But here, Lordship, probably situation is different, particularly in case Lordship. Because that claim for 2 months was allowed by the authority, Lordship. Considering
Yes.
the.
So the wrongful denial for the remaining months.
No, Lordship. No, Lordship may pass order, Lordship, I am not on that.
Not on that. We are just trying to satisfy each other, it seems.
Not definitely, Lordship.
Yes.
This is my humble submission, Lordship. So Lordship may consider the judgment also that type.
Yes, this court judgment.
Yes, Lord.
And what about this judgment not being considered? What is the concept of per incurium then?
Probably that was, probably in that case, I'm not about the facts of that case. Lord.
Same facts.
Same facts. So if this judgment is not considered, obviously the subsequent one by the same number of judges is per incurium.
Here it was 6 years.
6 years?
Yes.
In that case also, that.
Read, dena, unko dena chahiye. Give this judgment to
And
Mr.
in
K.
Lakwa, and Lakwa Tea State Lordship.
Yes.
In this case also about 6 to 7 years delay was there. That was not acceptable.
We seem to be confused and rather not reading the bare provisions contained in the notification. The notification nowhere speaks that any formal application is required to be filed.
That is.
The natural consequences provided, steps to be taken by the party, submit a statement of duty, get the refund by 15, that's all.
Lordship.
So there is no question of law framed that the statement of duty was not filed by 7th, so they are not entitled to the refund.
Probably this is the case of the department, although it is not specifically written there.
It's not the case of the department. Department says verified.
No.
We'll only refer to that.
Lordship, if suppose, just for argument.
Yes,
If suppose they have not filed there within 7 days and subsequently after 5 years or 10 years, they file. Whether.
Then you would rather burden them with that duty. Instead of giving them the refund, you would have many more consequences. Not furnishing what is the consequence of non-furnishing of an income tax return? within the stipulated time. The same consequences are there.
They will not be allowed to any exemption.
So that is what the consequence is.
Yes, Lord. Same thing.
Same thing here. All right.
Deeply.
Arguments heard, order reserved. Judgment reserved.
Deeply.
So number 21.
So this is again is central excise appeal where sanguine credit was denied to them for one part. Lordship, in this case, we prepared an appeal also that was withdrawn on the ground of monetary limit.
Monetary limit.
In that application, we have annexed to clarification notification. That is not available here. May I pray that Lordship that
On request of Sri KL, registry shall tag the file of
central
excise appeal number so and so
2 of 2020.
within bracket disposed of with this record of this said appeal with this appeal with this excise appeal and list the matter thereafter.
Not.
So number 22.
Yes.
May please, your Lordship, my lord. In this case, my lord, I am praying for a little agreement, my lord. Today I have some personal difficulties, my lord.
All right, let counsel Mr. So and so. Your good name, sir?
And she does.
And she does. Please for submit that he is not prepared with the matter today and seeks adjournment list after 4 weeks.
God bless you, Lord.
So number 23.
Yes, Mr. Chaudhary. What is the matter about?
This is a matter relating to termination from service after a
Full test.
disciplinary proceeding and the impugned order Lordship, order of the learned single judge, your Lordship will find at page 89.
89. In which service? CRPF.
He was in CRPF Lordship.
All right.
And the allegation Lordship against him was Lordship while he was proceeding on leave in Jammu. He was proceeding.
And he was carrying bullets in his
He
baggage.
was carrying bullets in his bag. 23 live bullets were recovered. And
No defense assistance.
that is, Lordship, one thing I have gone through the records, but I do not find anything on record of him asking for a defense assistance.
Asking or you are to offer?
Lordship, and the learned single judge proceeded on the premise that Lordship,
Probably you can ask for a remand.
Lordship, that
No.
I would probably ask for that. But
Have you made a prayer?
I have not made a, this is something well before my time, Lordship. So here is a case, Lordship, otherwise if.
All right, you argue on merits.
The learned single judge Lordship proceeded on the premise, Lordship, that the departmental witnesses, they were hearsay witnesses, and the person who had actually seen was not called on.
Not examined,
was
yes.
not examined, Lordship. But Lordship will appreciate this being a departmental proceeding, the strict rules of evidence.
Maybe. But you have to prove the allegations by preponderance of probabilities.
Yes.
How do you
Lordship.
prove it?
The statements of the persons who were examined, Lordship, I take your Lordship to that.
Yes, yes.
If I may take your Lordship to,
What is 27C?
that is the procedure laid down for the
Language.
Lordship.
He is unfamiliar with Hindi and you proceed in Hindi. That is a very substantive defect in your, significant defect in your inquiry.
Though Lordship, a stand has been taken in the appeal that he was given an opportunity to
Cross-examine.
whether he would like to be proceeded against in Hindi or in English. That stand is of course taken in the appeal. He said yes, but from the records I did not find, Lordship. I've gone through the records, Lordship.
Then what to do? All right, how do you prove the allegations? Let us see your witnesses.
Lordship, if I may take your Lordship to the statements of the witnesses, departmental witnesses. Lordship.
Yes.
If I may take your Lordship to page 46.
Khwaja Abdul Islam was the person who recovered the articles. right?
Lordship.
He was not called.
He was
Then who proves this fact?
the other, the departmental witnesses only say to the extent that they have heard that he was carrying and they have accordingly.
Whether the recovery memo is proved?
Lordship, that is not.
Then what do you expect? What do you expect? Has he been taken back in service?
No, Lordship.
No.
No, Lordship.
Not yet.
Because there's a stay in this appeal, Lordship.
All right. Read please then.
If I may take your Lordship to page 46.
Right.
Second paragraph. This is of course a translated Lordship. It's originally in.
Is there, no, it's okay. We can read in Hindi also, no issues. But whether that memo of handing over the ammunition was also proved or not?
That I do not find in the records. The only thing is that it has been handed over. That is on record. But by way of.
Who says so? Who received? Deputy Invigilator Khwaja Islam came to the camp with force number so and so, who was caught in Jammu Tawi railway station.
Yes.
So there must have been an FIR also.
Yes, those things have not been considered.
What kind of perfunctory proceedings?
Lordship,
What more do you want?
I cannot go beyond the records, Lordship.
Read whatever statements you want to. Yes.
I'm just. Page 46, Lordship.
Yes, we have already read that.
Lordship.
Read what do you want to refer?
On March 31/3/2003, so and so I joined this force from August 2005 onwards. I am taking charge of my duty on 6/6/2008.
Read the fourth question on page 47.
Lordship. At present, where is that RTO about whom you have mentioned?
Who informed you about force number so and so, recovery of force so and so from him? Her second question.
Yes, Lordship.
From RTO Inspector Khwaja Abdul Islam.
This particular person has not been examined.
Then did rounds were recovered from inside the bag of force number in front of you?
Yes,
No.
No
Rounds were recovered by RTO in police station.
In police station.
And reported this and handed over the above mentioned rounds.
Yes, Lordship.
What prevented you from examining Khwaja Islam?
Lordship, he has not examined, Lordship.
So there is no, it's not your case that the DO, delinquent officer, he was instrumental in non-examination of the witness. It's not your case.
It's a case, Lordship, where the delinquent official, Lordship, he also did not adduce any evidence to contradict.
Why he was required to? You did not prove anything. Why was he required to bang his head by producing evidence? You didn't prove anything.
Lordship.
And then above all, he is not aware of Hindi to conduct inquiry in Hindi. Not a single question put in cross-examination. It is his good luck that you didn't prove anything, but then you don't provide him assistance. The inquiry is a sham, total sham.
Lordship,
All right, read your findings.
That is, Lordship, extracted in the order, impugned order itself. At page 92. It's Lordship.
Who is Lal Singh? Was Lal Singh examined? Was Lal Singh examined? Read page 50. This Swaran Singh says that after receiving order from Commandant, sir, along with guard, went to TC, brought 23 rounds of so and so from Deputy Invigilator Lal Singh.
Yes,
Who is Lal Singh?
No, Lordship.
Not examined. This is pathetic on the face of it.
And the report of the inquiry officer also, Lordship, I'm very sorry.
These guys, Mr. Chaudhary, these guys are not attuned to these proceedings. There's no training provided to them. They just live in their own environment.
And this is absolutely, if your Lordship will come to page 92, it is extracted. Lordship, this is the first time I'm seeing an inquiry report of this kind. Lordship will see.
Yes.
At paragraph 10, it is extracted. That is the finding of
Para 8, the inquiry says he does not have knowledge of Hindi.
Yes.
So what confession is extracted, that the page 92, that is the judgment of this court.
judgment, it is the
Ah.
findings of the
Oh.
inquiry officer is extracted at
All right.
paragraph 10. So, Lordship, this, Lordship, I'm for the first time coming across this kind of
He doesn't even refer to the confession. The unlearned
That
single
is-
just says confession
he has
being-
to refer to the statement of allegations, the defense
Nothing.
statement, nothing.
Nothing.
Lordship.
so.
I leave it to you, Lordship.
Is there any option?
There is no option, Lordship.
Yes. Yes, please.
GST to it, no?
What do you say, sir?
My lord, Termination itself speaks a lot, my lord.
Mm,
I have nothing to add to it.
Nothing to add. All right. What is the
Perhaps, Lordship, these people, they need some
training? Training is necessary. At least in these courses, the sections which are dealing with the disciplinary matters. Even court martials, many a times we are seen, they're perfunctory.
This is absolutely cryptic, like, I have never come across anything like this.
Pathetic is the correct word for it. All right.
Lordship.
Okay, right. Judgment is up.
Matter number 24.
Yes.
May I please? Matter, Lordship, report was called for. Lordship.
Yes, 176.
Yes, Lordship.
Do you have it? All right. What is the matter about?
Custodial death, Lordship.
Custodial death.
Of the son of the petitioner, Lord.
And what is the relief sought?
Adequate compensation and some action, Lordship. Prayer, Lordship, page 10, Lordship.
There is a trial going on for 302. There is a trial going on of against what the accuser in.
Lordship, page 11, that this PS case number was lodged by the mother of the Lordship victim, Lordship.
Inquest report.
Vishwanath Sareli PS case number 4 of 19, Lordship. That was lodged by the petitioner, Lordship. Against the hiring official, Lordship. That is.
This is suicide committed in the custody.
As per their version, Lord.
So where is the postmortem report? Can we have a look at it? Do we have the postmortem report available? Call for the postmortem report. We'll examine whether it is a suicidal death or a homicidal death. There are stark distinctions. And Government Council shall keep the postmortem report of the victim, Mirzat Ali,
Lordship.
available for the court's perusal on the next date.
Lordship, there was an inquiry report where it was.
We need the postmortem report, madam. PMR list up to 2 weeks.
There is another issue.
Yes.
Petitioner has been granted some NCMC amount by the SMES Commission. They have approved and an amount of 2 lakhs been granted.
Maybe, but if we are to direct some action against the hearing officials, then we need the postmortem report. And you also keep the case diary available of the this FIR number. You just call the case diary, PMR will be available in that. And Government Council shall keep available the case diary of PS case number 4/2019, Vishwanath Chiraili, available on the next date. List on. We return this to her right now. 23rd May.
All right.
All right. Then.
May it please your lordship?
Yes.
With the consent of the other side, I beg to mention item number 11 of the day release.
Yes.
Finally, this matter may be adjourned for the day, your lordships.
Yes. Item 11, all right, counsel for the petitioner place for time. This contempt of 2020, why it's pending so long? Why?
Well, for the railways, I've already filed my affidavit in opposition in the matter. In fact, the matter has become infractuous, my lord. The order violation of which is being alleged in this writ petition, my lord, that already stood vacated by this honorable court, my lord.
Why adjournments are then?
Sir, leading counsel is out of station. Let the matter after 1 week, your lordships.
After?
1 week, your lordship. Any day, continuous your day.
That order, can you show us, Mr. Counsel?
Yes,
please.
Yes.
Whereby what is the order, date of the order under contempt?
Violation of which is alleged, my lord, is 10/9/2020. It was vacated on 16/9/20. And the interim order was to maintain status quo with regard to a building, my lord. Subsequently, not only the status quo was vacated, there was further direction to demolish the building, my lord.
Why, sir, are we keeping this contempt pending then? Or call your counsel tomorrow. He can address through VC. There is no order which is being violated now. The order has been vacated now. Why should the contempt be kept pending?
Lordship may be taken after 1 week.
Tomorrow, absolutely no. We just can't have frivolous files pending unnecessarily. Tomorrow, come back.
Deeply obliged.
Right.
Wait, please, Your Lordship. Hello, the item numbers 15 and 16 and 17, my lord, 10 days of duty. May I pray for some accommodation, my lord? 2 weeks.
Why 2021 contempt matters, sir? If the orders have not been complied with, let us punish the officers. Otherwise, why keep these files pending?
Lord, we wish to.
Certain issues are to be incorporated. Certain facts are to be incorporated in the contempt. I'm also in the petition and I'm not in the contempt. Certain facts which are there in the affidavit in opposition.
All right, counsel for the petitioner place for time. List after 4 weeks.
Yes.
Lordship, I like to mention item number 2.
Yes.
On behalf of Mr. B. Counsel, he appeared on behalf of the respondent. Lordship. He went to Hyderabad for treatment of his brother, Lordship. So let him come after vacation. I have already taken control of the petition.
List of 2 weeks as read by Mr. So-and-so appearing for Mr. B. Kaushik.
Oblige, your Lordship.
Mr. Chishti appearing for Mr. B. Kaushik. All right.
Item number 1.
Yes.
My pleasure. Lordship, pursuant to the Honorable Court Order dated 18/7/22, my lord, we have served notice upon the respondents, your lordship.
You
And
have
that
served notice.
Yes, that has been brought by way of filing additional affidavit, your lordship will find my additional affidavit. In my additional affidavit, lordship, page 21, that is the annexure 1. That is submitted before the deputy commissioner.
Page 21.
21, my lord. Annexure.
So you filed a representation.
Yes, representation along with the certified copy.
All right.
It was duly accepted, acknowledged
Okay.
by the
Lord,
commissioner of 39.
the petitioner has placed on record copy of the representation within bracket annexure 3,
Yes, my lord.
which annexures 1, 2, and 3.
Annexure 1, yes.
Annexure 1, which was furnished to the deputy commissioner, conveying the copy of the order dated
Order dated, your lordship.
7/3/2019,
Yes, my lord.
of which disobedience is alleged in this contempt petition. Issue notice to the respondent number
Respondent number 1, your lordship.
1. Third, issue notice to respondent number 1. Steps for service be taken in 3 days, 7 days. Rule is made returnable in 6 weeks.
Yes, lordship, may I submit one thing, lordship? Already new incumbent has joined.
Then you have to
We also
substitute.
We have also submitted the representation. before
Maybe,
the-
but you have to serve.
Yes, my lord.
Bring it is stated that some new incumbent has joined on the post of deputy commissioner.
Deputy commissioner, your lordship.
Deputy commissioner so-and-so during the pendency of this contempt petition. The said officer be brought on record. List after 1 week. Only after you bring him on record, we'll be able to issue notice.
Yes, obliged.
You just, Mr. Khan, you just mentioned only this. The respondent number 1 has been replaced by a new incumbent counsel for the petitioner to take steps for substitution. List after 1 week. All right.
Item number 3.
Yes.
Lordship, Lordship, can you give me 1 week? We are about to issue that compliance order within a week, Lordship. That is
The
what I have.
council, Mr. Chisti, submits that the compliance order shall be issued within 1 week.
1 week, yes.
List after 2 weeks, as list after 10 days.
Oblige, Your Lord.
So as to enable Mr. Chisti to bring on record the compliance order.
Oblige.
Report.
Item number 4.
No one? None present, 1 week.
Item number 5.
Lordship, the order starts at page number 8.
Never promotion. They always have orders. They come to anything. So it's only this heading is wrong. All orders. Yes.
The order starts at page number 8. The operative portion is at page number 12, para 9.
Page 12. Consider the proposal. All right, the instant contempt petition has been filed alleging non-compliance of the directions given by this court. Violent single bench of this court, by this court, by order dated so and so, passed in so and so. Did you place this order before the concerned authorities?
Yes.
Where is the proof?
Next page, Your Lordship. Immediately. Annexure 2, page 14.
The petitioner claims to have conveyed this order to the Joint Secretary, Border Routes Development Board, by the letter dated 21/12/2022, but till date, no response has been received to such representation, public communication. Issue notice to the respondent number.
All the respondents.
Why all respondents? You gave a representation to the Director General.
3, Your Lordship.
From respondent number 3. Only
2 and 3, Your Lordship. 2 and 3. Joint Secretary VRO.
2 and 3. Requisites be filed in 7 days. Notice is made returnable in 6 weeks.
Oblige.
Item number 6.
Lordship. Lordship,
Yes.
this is a contempt matter. Lordship, the matter is of 2019 and
Yes.
perhaps the matter has become infractuous.
All right, learned counsel for the petitioner states.
Lordship, I have been instructed by leading counsel of the for the petitioner that if your Lordship may accord us some time to get the updated information.
What for, sir? 2019, you have not argued the matter once. Why should we keep it pending? The contempt petition was filed in the year 2019, alleging non-compliance of the order dated 13/2/2019. Till date, no effort has been made by the petitioner's counsel to argue the contempt petition. Thus, it seems that neither the petitioner nor the counsel is interested to prosecute the same. Hence, the contempt petition is disposed of. Why should we keep such files pending?
Obliged.
Item number 7.
Yes.
The complex matter become infractuous.
As stated by counsel for the petitioner, the instant contempt petition is disposed of as having an rendered infractuous. Rule is discharged.
Item number 8.
Yes.
May I please, Lordship, in this case, I'm appealing for sole respondent, Lordship. In this case, Lordship, petitioner has not come forward, Lordship, to file an application, Lordship.
Has not come forward.
Yes, Lordship, today he received the communication. He will report it before the deputy commissioner within 7 days. Lordship,
So, sir, are we supposed to be an executing court that we keep on giving 3 years of time? The petitioner is not interested. Forget it.
In 2019, the letter has been issued by the deputy commissioner to appear before the Lordship committee, Lordship, but
Then why it is a contempt? You don't approach the authorities. Why it is a contempt? Let us know.
Yes, Lordship, that he will report before that.
So all right, you do it. If thereafter they don't do it, file a fresh contempt petition.
Lordship may close it.
Contempt lordship, and by this time he close the contempt petition lordship. And,
Yes, in view of the fact that the petitioner seems never to have approached the concerned authorities seeking by conveying the order dated 4/1/2019, the petitioner is given liberty to approach the concerned authority with a copy of the said order post up upon the requisite application being filed, the officer concerned shall take requisite steps in light of the directions given by this court. With the above observations and directions, the contempt proceedings are closed, rule is discharged.
Apply.
Much obliged.
Number 9.
Yes.
Your Lordship, as per office note dated 7/2/2023, Lordship, the new incumbents filed.
What is the contempt about, madam? Let us know first. 2019.
Lordship,
Yes. What is the order under contempt?
Lordship, the order is at page 11, Lordship.
Yes.
The operative part, the last paragraph, regarding the ex gratia amount of 2 lakhs to the petitioner. Lordship. That was the order of this honorable court.
What has been done, madam?
Lordship, I represent respondent number 6 and 8 in this contempt petition, your Lordship. Lordship, they have been only implemented on 9th of December 2022, your Lordship.
Understood, madam.
The communications has been made, your Lordship. Respondent number 8, the Deputy Commissioner has already forwarded the proposal to respondent number 6, your Lordship. The matter is under process, your Lordship. In a few weeks' time, the money will be sanctioned, your Lordship.
All right, and Council MS. So appearing for respondent number 8 submits that the requisite communications have been made between respondent number 8 and respondent number 6.
6 and 8.
6 and 8 for ensuring compliance of the directions given by this court.
Yes.
By order dated so and so. And in all probability, the claim of the petitioner will be sanctioned within next how many days? 3 weeks.
4 weeks, sir.
4 weeks. Re-notify after.
I am very.
4 weeks.
For the respondent number 5. 5 is the secretary of the personnel department. They have issued the notification. They are not the implementing.
Respondent number 5 is not an implementing officer, thus its name shall be deleted from the array of respondents.
I appear for one, the former commissioner secretary. So personnel has got nothing to do.
1 and 5 both deleted.
Much obliged.
Item number 10.
May I please, my lord, in this case, new incumbent has joined the office, my lord.
What is the order, sir?
My lord, there is some illegal construction, my lord, and this word directed the chairman municipal board to look into the matter, and after hearing both the parties passed the order, my lord.
So what has been done thereafter?
My lord, thereafter, my lord, notices were issued, my lord. Once one hearing took place, my lord, but thereafter no order was passed, my lord. In between, there are some developments, my lord, so I may be allowed to implement the new incumbent, my lord.
Have you conveyed this order? Your annexure B simply is a typed copy.
Yes.
Where is the proof of service?
My lord, that.
You simply type out a letter and place it with the contempt petition. How did you convey it to the authorities?
My lord, that was served in the office, my lord. That is my instruction. My lord.
How do you satisfy the court, sir?
My lord, the lordship may take up some other day. I will satisfy, my lord, by what way it was served.
On a perusal of the land council states that for the petitioner state that the respondent number 1 has been transferred during pendency of the contempt petition and is transferred and replaced by another officer during pendency of the contempt petition. counsel for the petitioner to take steps for bringing on record the person presently holding the post. In addition thereto, this court feels that copy of the order under contempt dated 13/3/2019 seems not to have been conveyed to the chairman, North Lakhimpur Municipal Board, Lakhimpur. Thus, counsel for the petitioner to file requisite documents to satisfy the court in this regard. List after 3 weeks. On this aspect, satisfy the court on this aspect. Yes.
Matter number 12.
Yes.
Well, way back on, my lord, 20 March 2019. Way back, my lord, on 20 March 2019, the petitioner, my lord, who was serving as a principal of the college concerned, my lord, he was my lord, purported disciplinary inquiry was, my lord, conducted. And he was, my lord, he had already, my lord, retired in the meantime. And my lord, the order of penalty was, my lord, 20 March 2019. Against that, my lord, order of penalty, the petitioner had filed a departmental appeal. And he got to file a departmental appeal, my lord, in the month of May. That is on 27 May 2019. That is not disposed of.
Still not disposed of. Yes.
See, regarding that appeal part, lordship may give some time, I will obtain. Otherwise, pension part, lordship, we have already issued provisional pension, lordship, and college.
Why the appeal has not been decided, sir?
That part, lordship, I have to obtain instruction, lordship.
Obtain instructions means what?
Lordship,
The notice was issued when?
lordship, in the meantime, the present new incumbent is come, lordship. So lordship may give 1 week's time, lordship. In the meantime, I will.
And counsel, Mr. So-and-so representing the respondent number.
Lordship, I am for.
My lord, now it is the respondent number 5.
Respondent number 5.
My lord.
Commissioner and Secretary to the Government of Assam, Higher Education Department, praise for and is granted 7 days time to apprise the court regarding the fate of the appeal filed by the petitioner within bracket, if any, against the order of penalty dated 20th March 2019. List after 1 week.
My lord, it is already filed, my lord. The learned single judge are.
If any, delete kar dena.
My lord.
Yes.
My lord, I pray for lordship, I fix there after 20 people, lordship. I am out of station.
All right. List on 3rd May.
Lordship, lordship. Oblige, lordship.
Deeply obliged.
Matter number 13.
Yes.
May I pray before lordship, as per wish to dated 7/2/2023, service deemed to be completed upon respondent number 1, 2, and 3. They in the earlier order they were ordered as to file Pokolanama, but till that they are not able to respondents able to submit.
What are you trying to say, sir?
My lord,
We are not able to understand.
my lord, as per office note dated 7/2/23.
Yes. This is a contempt petition against
My lord.
private individuals
Yes, my lord.
for non-compliance of which order?
Yes, my lord. This order, my lord, order para height of this petition, my lord. High court order of this court.
Annexure 1.
Next one.
And what is that order? What is the import of that order?
Order, my lord,
Yes.
is number 46.
Page 14 is the order. Order dated 21/3/16. That is the order.
3/11/2017, my lord.
3/11/2017. Yes. So what has happened thereafter?
My lord, this petitioner, in this case, as per order, a status quo was maintained and he was until now there. And some private respondent of this area, who are in this case, disturbed.
How do you say, sir, that you have been disturbed?
My lord, that means they wanted to shift from this place.
Who wanted to
Private
shift?
respondent, my lord.
Yes, so
2 and 3.
so who they wanted to shift you from this place to displace the petitioner?
Who that place was status quo maintained, my lord, by this.
So how do you say that the petitioner has been disturbed? What is the proof to satisfy the court? Where is the allotment? Not to dispossess, you have given notice, but where is the proof that you have been dispossessed?
Yes, ma'am.
Yes. Do you say in your contempt petition that you have been dispossessed? Read.
My lord, para 7.
Yes.
The Honorable Guwahati High Court passed an order dated 3/11/2017.
Yes, all right.
It was directed that till disposal of the writ petition, the de-reserve order of scheduled land would continue. And our petitioner is under the stay.
Yes, forcefully. So who are the contemners? Were the contemners party to the writ petition?
My lord, MD Azhar.
Were the contemners party to the writ petition?
My lord, 1, 2, and 3.
Yes. Are they respondents in the writ petition?
No, my
No, then how they are guilty of contempt? There was no direction to them.
their committee, sir. My market committee.
Was the market committee a party in the writ petition, please? No. Then how they are guilty of contempt? File a criminal case for trespass. That is the only way out. All right. And counsel for the petitioner is not in a position to dispute that none of the respondents who are arraigned in this contempt petition were party in the writ petition, wherein, the order to maintain status quo was passed on so and so. In this way, the matter, manifestly, the private respondents cannot be held guilty of contempt. Hence, a contempt petition is dismissed, rule is discharged.
Item number 14.
Yes, item number 14 of it.
Yes.
Here we have already issued a compliance order on regarding regulation and payment of areas related to the petitioners. Subject to the approval and concurrence of the finance department. Now the file has been moved to the finance department. The sanction from the approval from the finance department were awaited. Otherwise, we have complied with that order, and he was regulation. The two petitioners, they were regularized to the post of
Assistant teacher and Chowkidar.
and Chowkidar losses, and their salary with effect from 19/11/91. That has been issued subject to the approval of the finance. That we are awaiting the approval of the finance department. Not also. This is the order.
The finance department is not a party.
Party is
So far as education is concerned,
No,
it's
sir,
a
they
party.
were party.
Yes, yes.
Who is representing?
Even in the repetition also, they were party.
Just hold on. Who is the officer?
Is this,
Respond number 6.
yes, Samir Sinha.
Yes. You have pleaded him?
Yeah,
Yes.
7. Yes.
Yes, yes. Who is for penance? You forwarded it on what date? 21.
E-file, yes, that file bearing number E-file, it is given 2222604 losses.
21.
Yes, no.
Who is for penance? All right, keep Mr. Samir Sinha present in the court on the next date. All right, likhiye. The council, Mr. Chisti, representing the education department, has placed on record that the officers of the contemptor officers of the education department has placed on record copy of the order dated 28 July 2021, as per which, the proposal to afford benefits of the order dated so and so to the petitioners has been forwarded to the finance department. However, nearly a year and 9 months have passed, but till date, the finance department has not taken any action on the said communication. In this way of the matter, comma, either the consequential compliance order be issued by the.
But in the causeless lawsuit, their name is not shown. How the service is completed or not lawsuit upon the finance department, that is also be seen.
Let us see.
But here, their name is not shown in this causeless.
Let's check. Yes, you're right. Hmm.
Listen, as per office note dated 1/12/2021, we have taken steps upon the 1, 2, 3, 4, 6, and 7. We have taken steps upon that.
Let's see.
Also, office note dated 1/12/2021.
Oh, but thereafter, respondent number 7 was transferred and
Yes,
replaced by
Lordship.
Mr.
Yes.
Sinha.
Thereafter,
Samir Sinha is the finance secretary now.
no, still now, he's finance.
Yes.
All right. Service has not been effected on the principal officers of the finance department, that is respondent. In 3 weeks. Before this, you take note that has placed on record so and so, as per which the file is pending for approval, concurrence from the finance department. And then you issue notice. Copy of this orders shall be conveyed to the principal secretary finance, Government of Assam.
Number 18.
May it please the lordship. Lordship, contemner number 2 has filed an affidavit wherein they have stated that the department has been bifurcated and attached to some other ministry of Union of India. And we have put to notice to the ministry, lordship, on 8th of April, lordship. So we will need some time to file IA for implement of party, lordship.
Counsel for the petition submits that in view of the you already filed some application.
Lordship, that was allowed, lordship. And contemner number 2, by way of allowing this, that IA lordship, contemner number 2 was impleted. And he has filed affidavit recently.
Already in
And
view of the
stating that-
affidavit filed on behalf of the newly implemented incumbent regarding bifurcation of the departments, counsel for the petitioner prays for and is granted 4 weeks time to move the necessary implement application.
Lordship.
Respondent number 2, actually, we have no role, Ministry of Skill is the department, we are a Ministry of Labor, secretary. So
we can delete their name.
Lordship, initially they were there in the writ petition, lordship. In their presence, lordship, order was passed.
We will not pass any order against you, otherwise need not file a reply. You can continue to represent, that's okay.
I'm obliged.
Oblige, lordship.
All right.
Number 19.
Yeah, please, the matter has become infractuous.
As stated by counsel for the petitioner, instant contempt case is disposed of as having rendered infructuous.
Oblige.
Rule. Why rule, I think, is no rule has been issued. Infructuous.
Number 20.
May it be your lordship.
Yes,
A notice upon the respondent was served, my lord.
has been served.
My lord.
You are appearing, madam.
Lordship, for the respondent number 2.
Respondent number 2. 1 and 2 both have been served. You represent only 2. Who is there for respondent number 1?
Respondent number 1 is the deputy commissioner of Dhamaji district.
Who is the effective party? Who is the implementing authority?
My lord, respondent number 2, my lord.
2 only. What do you say?
Lordship, due to insufficient funds, the actual authority is the Director, Welfare of Plain Tribes and Backward Classes, Assam, Lordship. They are to provide us the funds. And due to non-availability of funds, Lordship.
You file a reply or counter affidavit, whatever you want to do.
Lordship,
Bring these facts on record.
Lordship.
MS so and so appears for the respondent number 2. She prays for and is granted 4 weeks time to file counter affidavit on behalf of such respondent.
Number 21.
List up 4 weeks.
21, my lord,
21. 21 is also same, Lordship.
Same.
20,
all.
21, 22, my lord.
21, 22.
My lord.
All 3 connect kar dijiye तीनों.
My lord.
Connect. 4 weeks time. to file reply.
All right. Matter number 23.
Noted, these are connected together. Okay, yes.
Lordship, as per office note that 31/2023, Lordship, service is not complete, Lordship.
Not complete.
So I may be allowed to take fresh steps, Lordship.
Service has not been effected on the respondent number 1. You are appearing?
Our name is not.
Mamta Ojai, AES Director, Secondary Education. You are not appearing?
I can appear, Lordship.
All right. Mr. Chisti appears on behalf, puts in appearance on behalf of the respondent number 1. Copy of the contempt petition be provided to him.
Yes, bro.
He prays for and is granted. 4 weeks time to file. Counter affidavit of the compliance report on record. Name of Shri Chisti shall henceforth be reflected in the cause list.
Yes, obliged.
Matter number 24.
May I please? Well, this is the contempt matter for non-compliance of the order dated 10/1/2022, my lord.
Yes.
4 weeks
time to file my affidavit, my lord. This is regarding non-payment outstanding bill, my lord. 4 weeks time to filing the affidavit.
Mr. So and so puts in, what's your good name, sir?
That's what I love.
As Boda appears on behalf of the respondent number
Both the-
1 and 2, both respondents. He prays for and is granted 4 weeks time to file counter affidavit oblique compliance report on record. List up 4 weeks.
The number 25.
25 is similar prayer, my lord.
Similar prayer. All right, 4 weeks time to file counter affidavit. All right,
The number 26.
Similar prayer, my lord.
same.
I pay for both the respondent.
Yes. Are these identical matters? No,
Identical, they are separate orders, all regarding to outstanding bills, my lord.
regarding
Outstanding payment of outstanding bills.
outstanding bills. All right.
From
You file your
up to
affidavits.
29.
Need not club them. Need not, there is no need to club. But we'll grant you 4 weeks time to file
Up to
reply.
item number 29.
29, 4 weeks time to file reply. Order can be same, but no need to club.
Problem.
Yes. Or we can club them. It will be convenient for you. They'll come up on the same date. You give a same date. After 4 weeks, you give a date in all these matters.
Problem.
Yes.
Matter number 30.
No need to connect. Give a same date, fixed date. Yes.
May I, your lordship, order violated has not been complied in letter and spirit. That they have passed a vague order and that's all. Order is.
They have passed a
Vague order, which has nothing to do. It was demotion. Market is still being enjoyed by the opposite party and contemners are helping them. Because district administration is in their hand. So deputy commissioner has not in fact stayed the
so
order. That is the order.
it's a paper order. All right. How do they execute? If someone goes there and operates the market, what are they supposed to do?
My lord, for that we have filed a petition also before the 2 petitions. One before the DM that has been kept in abeyance after this order. And another before the SP, Nalbari.
So all right, if they don't take action, file a fresh writ petition.
My lord,
They have issued a paper order that yes, we will not hold a market.
Let them file affidavit. We will file a.
All
reply
right.
to it. Let the matter be heard.
File an
If
affidavit.
this is the way of dispensation of justice. People will not come to the.
Mr. Counsel, the issue is that if people of the area decide it on their own, that we will hold a market, what the authorities are supposed to do?
That is correct, but
We are trying to stop the street vendors. How far are we successful? Are these things for the courts to take into account, or this is a policy matter of the government? Is the court supposed to administer justice or administer administration?
Lordship, to my supposition and faith, court should be stringent in executing its order.
All right, all right, you will not hold the market. They say we are not doing it, sir.
The market, but
Will
not at the cost of life.
They say that we are not holding any market, sir. If people go there and sell their goods, what can we do?
They let
Simple.
they stand.
May I submit, my lord?
Yes.
My lord, actually, there are 2 other different markets, my lord. And there are some, the deputy commissioner, my lord, ordered the petitioner's market to be closed as some, because of some peaceful, my lord. Whereafter, my lord, in the single court, my
You
lord.
file an affidavit, Mr. Counsel.
My lord, my lord. The
Counsel,
petitioner-
so and so appearing for the respondent contempt, praise for and is granted.
2 weeks.
2 weeks
time,
time
Lord.
to
We are
file
not able to
affidavit.
hold it.
Already complied, my lord. I will file affidavit.
Affidavit
My lord.
in compliance affidavit.
Yes,
List of 2 weeks.
my lord.
Number 31.
Yes.
May I please your lordship, order dated 8/6/2022, passed by this honorable court has not been complied with, wherein it was directed to the respondents to restore the electricity
Electricity connection, yes.
Yes, my lord, this is the instruction. What has happened, my lord, the order says that for applying of temporary connections. And my lord, as per our code, my lord, we have written the letter to the committee here, the secretary of the committee, to give us the names of the people who for whom the for whom the temporary connection has to be done. And my lord, there is a prescribed method under which they have to apply for it.
Members of the petitioner committee.
Yes, my lord, at page 5, my lord, I have given you.
All right, what do you say?
Yes, my lord,
This is a committee which is representing the cause of the persons concerned.
Yes.
They have to identify the names.
Yes, my lord, they have to apply, my lord, they have not applied also.
They need not apply.
My lord,
There was no direction that they should apply.
No, my lord,
There is a mandate upon you to restore the connections
No, my lord, what
of the members of the petitioner committee.
is,
Why are you insisting? You are not affording them a permanent proper connection.
no, my lord, that
It's
is.
a temporary connection.
My lord, but as per the code, my lord, as per the code.
Yes, something lot.
My lord,
lordship.
I'm just submitting the code, my lord, here.
Hmm?
The code, my lord, and the letter. My lord, as per the code of the AERC, and 4.4.2, for temporary power supply, there is a proper format that has to be given. My lord, because this areas where there is no LTHT connection there. So my lord, if we do not get the proper format, it will be difficult for us to give connection. My lord, may 4.5.2, my lord, I have orange flagged it, my lord. My lord, temporary connection shall be granted for a period of 3 months at a time and may be extended up to 1 year. The applicant shall specify the date and time when the temporary supply is required. The supply shall normally be given 48 hours before the time when supply is required, subject to the receipt of payment within the time frame specified.
All right, you place this on record.
Yes,
Provide them a copy.
Yes, ma'am.
And council so and so has placed on record. Copy of the communications indicating communications issued by the APDCL, as per which, the secretary of the Yusuf Nagar Unnayan Samiti has been asked to file applications for temporary election connections in accordance with section 4.52 of the AERC regulations.
My lord, one more line may be added, my lord, pleases, my lord, in the because the restoration for LTHT connection transformer was supposed to be required, and that was.
But how are they getting electricity earlier?
That was dismantled by the government when the eviction process took place. So that is why, my lord, if we do not get the format and the 4.5.2, it will be difficult for us to give a restoration there. And this is a temporary connection, my lord. That is why we have specifically said that hence for restoration of power supply, temporarily additional construction of HTLT network along with the new transfer.
That is your headache. That is your headache. Why are they required to go into that?
Because of that, the format of 4.5 would be required. That is what
That's what we are saying. They'll make the applications. Copy of the communications be provided to the petitioners council, who may seek instructions accordingly. List on. When do you want? You will have to instruct your clients,
Yes,
file the requisite application.
yes, lordship. And immediately after being lordship,
List on.
I'll ask my client to be there with the list.
Yes,
Yes, lordship.
No, my lord.
26th April,
Yes,
My lord, can
Yes.
it be on 28th, if my lord?
28th.
28th.
Yes,
April. My lord, by that time we'll file an affidavit.
yes. The affidavit on behalf of the respondent contemners be filed in the meantime.
Obliged, lordship.
Number 32.
32, lordship, we have complied with the court order, lordship. I have given a copy to them.
What do you say, sir?
And
Yes.
Case was rejected.
Counsel
because
for the-
District Scrutiny Committee didn't recommend his name, Lordship.
Mr. Chisti, please don't record copy of the
He may challenge
communication.
this order,
Public order dated 2nd January 2023, being the, whereby, the name of the decision has been taken not to recommend the name of the petitioner for provincialization.
No, Lordship. His name was not recommended by the District Scrutiny Committee. That's why his case cannot be considered for provincialization. That was the finding. The second
Uh,
case order.
Could not be recommended for provincialization
Yes.
as his name was not recommended by
DSC.
by the
District Scrutiny Committee.
District Scrutiny Committee.
Yes, Lord. That,
Needless to say that the petitioner shall be at liberty to challenge the
Yes.
said order if so desired. However, the order under contempt dated so and so has been complied with, hence the contempt proceedings are closed, rule is discharged.
obliged.
Done.